what has also happened, my lords, is that R3, who is my son's grandmother's distant cousin, files a guardianship petition not for herself, but for two domestic servants in the before the guardianship court. Now, I am the...
But just 1 minute.
Yes.
Not for domestic servants. I think she's wrong.
1 minute, 1 minute, please. Just 1 minute.
Not at all.
Look, we can't become the guardianship court over here.
Yes.
You're the natural father. There's
My
no
lord.
doubt about it. There's certain allegations flowing from both the sides. One thing I couldn't understand, why did you video record that? And why? What difference does it make if his friend goes to the house?
It's not a...
Who's that?
That's them.
That's them. I am not being allowed.
No, please. He went with one of his friends or something.
Not he went with her.
1 minute, please.
But I'm
Just listen.
That's him, not me.
That's
Not
me.
me.
And you can't start video recording. He may be going there because he's going to a house which is in occupation of third parties to protect himself from making false allegations, etc. He may be taking a spy camera or maybe recording it, that's fine. But please understand one thing. He's the natural father. His right under the law is there.
May I just say this?
Please. And number one, if you can bring your friends to in the house, they can also,
I'll come after this.
they can also bring, either that will not be permitted. So what we're going to try and say, subject to what you say, this order will continue. The visitation rights and everything will continue. Let the matter be decided by the guardianship court. There is already civil suits pending.
I am respondent number 4.
My lords.
I am the first, just 1 minute. I am the first cousin. Now, I have lived with the boy. Lord,
Get it.
I am the first cousin. I am not being allowed in the house just like him. When your lordship passed an order that all people who had been meeting him from 2005 to from 2000.
Please go before the guardianship court.
But for 12 years he was living with me. I was there.
Please.
I got married. Now what is happening?
Please, Miss.
No, I'm covered.
We don't want to go into allegations, counter allegations. The allegations being made because of the property reason.
Yes, I agree.
Yes.
Now, my lord, you're not.
And also the way in the LLP, the husband of one of them has been brought in.
He's
Yes.
not the trust.
They are interested.
Not trust.
This is
He's
it.
come as the
We
representative.
are not commenting on it, but this requires a deeper scrutiny.
Please have
You
25th.
cannot undertake that scrutiny in the court.
Please have
By-
just 1 minute.
Curiously,
Please have 25th
guardianship-
order.
the
Allow me to
guardianship
meet the
court-
child.
the guardianship court repeatedly adjourns the matter very curiously. Now, my question is this, my lords. We come in a prerogative writ before my lords because
Can't do more than this.
when the
We
father...
cannot become the first court.
Yes, but when the father is alive...
Look, what is the reason for habeas corpus? The reason
Because
for
he's-
habeas corpus is 1 minute, please.
Yes, my lords.
You're also not staying here. You're staying in Switzerland. You are not also staying here. Please go before the guardianship court. We
Yes,
just confirm we'll say this order will continue till the guardianship court.
But my lords, right now he's in the custody of domestic help, my lords.
No.
And
But
he is in
this-
custody.
Please go there and take the.
This order allows me also. But what they are saying is that your name is not in this order. Please read this order.
I've seen that sentence says whoever was earlier being.
Yes, I'm one of them. I can't be
Go
stopped.
before the guardianship.
Please ask the guardianship court to decide expeditiously.
May I make
Okay.
a prayer?
In 6
This
weeks.
order will remain.
May I make a
Right on.
May I make a prayer in this regard, Manoj?
Yes.
What is happening is before the guardianship court, time and again objections as regards the lawyer appearing, the power of attorney, though it's apostle, everything.
That field will say nobody will object to the apostles
Yes.
Please,
verification
Your
of the
Lordship,
power
and
of
kindly make it.
That's utter nonsense. Utter nonsense. That's just technicalities coming in. Shows the malefice of the person who's raising those things. Yes, you have been raising that.
We have not been.
You have been raising that. Mr. Luthra, let me put it very clearly that you have been raising that. And there's no question. He is entitled to take his friends. Similarly, Mr. Patwali's clients can go there. You are nobody to obstruct anybody entering. It's not your house. Please understand that. It's not your house.
Just say one thing. Chip is right. counsel.
And you should not,
My lord,
you should not have done the videography either.
Can I complete my? Complete what I'm saying. If your lordship permits me, I understand. Your lordship is right. I've counseled them on no question. The only request not to them is, and I don't even wanted to put it, but in your lordship's presence, I'm making a request for. It should just be that they should not get people who are bouncers in essence.
No, that's fine, that's fine.
That's the concern, Lord.
He's
Because
fine.
it disturbs the child. I can show your lordship the photographs of the person who came. It'll be apparent. I'll leave it at that.
Right on.
My presence will be soothing. Please say all
I know
parties.
that.
Lord, please indicate that I am also allowed. Lord.
This is an unfortunate matter wherein the father of the child, within brackets, name suppressed, brackets closed, has filed a present specially petition impugning, claiming that he is not being allowed to interact and meet the child. Full stop. Impugned judgment passed by the impugned judgment dated
29/20/24, my lords.
29
September.
29.
20th September 2024 has referred to the report of the court commissioners who had interacted with the child, etc. and has observed that the child was not in anyone's custody. To stop. While hearing, next paragraph, on 25/10/2024, the court had passed the following order, copy that order. There has been substantial compliance of the said order, though applications have been filed.
I have not been allowed to meet.
1 minute, please. I said substantial compliance.
Okay.
Mr. Patwari, I know. How do you think I'd forget
All right.
what you said?
Great.
With substantial compliance of the said order, though applications have been filed, making allegations. Full stop. Making allegations and counter allegations.
4.
It is also submitted on behalf of respondent number
4.
on behalf of Damini and Goswami that she has not been permitted to meet the child. Full stop. We would only observe that the
And just record the statement, she had not met the child since 2022 because
it doesn't make a
it was a
difference.
strange.
Doesn't make a difference. Let her meet the child. What is the difficulty? Please, let her meet the child, please. You're not nobody's to decide. You're nobody to decide whom she.
I'm just pointing out.
1 minute, please. You're nobody to decide that. You can't solve that. You're not, please, don't take upon yourself the burden which is with the, as long as there is nothing wrong done.
To meet the child.
In fact, let me put it, I'm of the view, let there be CCTV cameras, but the photographs should not be recorded. The recording should not be made available until unless required
But I
by
think
the
that's a
court.
appropriate.
That's a very
Because
fair,
the CCTV will be
very
useful.
fair suggestion.
Grateful.
It's a good idea. It's a wonderful idea.
Full stop. She should be permitted to meet the child. Full stop. We have, next page, we have, in order to prevent, don't say we have, in order to prevent any untoward incident, we deem it appropriate to permit who will install the CCTV camera?
We'll get it installed.
No, we'll get it done.
We'll get it.
We'll get it done.
No,
I'll get it done.
I'll get it.
We, 1 minute, we'll appoint a court commissioner for that.
That's best, Lord, that's best.
That's best.
Kindly.
We deem it appropriate to
In fact,
appoint
the same court commissioners would gone, we install it, but
No, my lords.
Those-
Distinct one.
we direct
Why distinct?
We direct, just one minute, we appoint a court commissioner, namely any advocate from Punjab and Haryana High Court.
But here,
In this room,
in this
in this
room,
courtroom,
Mr. Chitarth is there.
you can't be yours.
Chitarth is here.
Yeah, result.
He's an AOR over here.
but miss, not,
If I, will you be able to handle it? Go there,
Yes, Your Lordship.
Mr. So-and-so, advocate who's present in court, is appointed as court commissioner who will ensure installation of a CCTV camera with video recording for a period of 56 hours. Should I make it longer?
Let them be there, not without time.
It has to be, there has to be time. The PD or the, for 96 hours, which will be installed at appropriate locations in the house designated by the court commissioner. To stop. The expenses for installing the said CCTV cameras will be paid by, what's your name?
R3, Lord, respond number 3.
Responding number 3.
We'll also pay that much.
Make a difference. The money is with them.
Very good, very good.
So the trust, the money.
Yes, respond number, correct. But
MS
through the trust.
Kalandi Hamal.
So, cut the trust.
But through the trust of the individual, Lord,
With the trust, we can.
No need to.
I leave it to your lordship.
Yes.
They are also challenging that.
Why not may put it whichever way.
You pay, please. Let me better you
He'll
pay.
pay.
Full stop. The aforesaid directions will continue. And continue to operate. Full stop. However, the parties may, it's like that, also aforesaid directions will continue. The parties have already moved the guardianship spot. Their proceedings are pending. There are also civil suits pending in the three parties with regard to certain assets, etc. Stop. The above interim order will continue to operate till it is modified, vacated, or affirmed by the
But that,
guardianship court. So stop. We request the guardianship court to take up the proceedings for hearing expeditiously. So stop. Guardianship court may be entitled to take help of a counselor if required and necessary.
Lord, there is, may I just point out, the matter before the LLC, not there's a, LLC is the local level committee constituted under the
National
National Trust Act. Lord.
1999.
Now the guardianship court is
No,
not.
Lord, it's the LLC.
We are-
That's
We
a
are in
special
the
act,
guardianship
special
court.
clarification
But-
act for
We are in the
LLC. Lord, I'll give the name of the.
Just give
No,
the
1 minute. Is it not? I thought it's pending.
No,
before
Lord.
the
It is.
Yes, it is. Our
My
petition.
guardian.
Guardianship.
Can I just?
No, no, it will be before the guardian.
No, Lord, no, Lord,
Lord,
this
that
act should
is-
have changed, Lord. Please,
No.
Supposed to be.
My lord, I'm sorry, with respect, Lord, I'm sorry, there are,
No, court, look, we
My lord,
always.
can I just tell your lordship? Lord, the National Trust Act came into being whereby petitions are to be preferred before a body called the LLC, local level committee under the statute. I'll show your lordship, Lord. Just, I'll show you the rules and the.
But the fact of the matter, that guardianship court will oversee.
No, Lord.
Yes.
No, Lord, no, Lord, just see this, see the act.
No, Mr.
My lord, see
NTT
the
Act
act.
doesn't apply.
Lord, it's an act of 99, the law is.
NTT Act
Please.
applies if you want to
My
take
lord,
the guardian or
Lord, Lord,
whose otherwise
with-
is capable.
Let that be issue be decided.
My lord,
Whether or
my
not,
lord, the-
let it be decided by.
Can I, will your lordship give me a moment to see the legal position? I'll leave it to your lordship. Because they are pending before the LLC, Lord. It can't-
No. We
Yes,
all
they
let
are.
before them.
Yes, they are, but I'm saying now, Lord,
Be by the guardianship.
my lord,
Cannot be.
that is pending,
I
Lord.
know.
Please just see this for a moment. Please see the rules. Lord, there is now in 99, just hand over.
How can rules prevail over an enactment?
My lord, there is an act now. This is.
No, sir.
I am also happy.
Yes, now see this, see act.
Guardianship.
We'll pass on the.
Lord, the guardianship act is the old act.
It is the
Lord,
guardianship.
this is the.
Notice has already been issued.
Now, please see, Lord.
Then
Now,
the issue of
now please come to,
Section 14.
Chandigarh rule.
please come to, Lord, section,
14.
48.
please come to chapter 6.
No, Mr.
My lord, please see chapter 6.
I'm sorry. I'm sorry, it will be before the
Madam,
guardianship
please
court.
see chapter
No,
6.
please.
Madam, please see chapter 6 for a moment.
They may take the head of the,
Oh, it's a separate statutory body. Please see the statute, not at least. Madam,
The-
with respect, Lord, I'm sorry.
I had gone.
My lord, there will be a, not guardianship court is, not jurisdiction has gone to new body.
But,
Please see it for a moment.
Mr. Luthra is correct. So far as these
Madam,
these are
No,
concerned,
no.
Madam, please just see the statute for a moment and see 14 to 17.
the guardianship court will be entitled.
Madam, I'm sorry, my lord, that will be
maintainable or not,
Madam,
Will be where the
allow me a moment to show your lordship the statute. If I'm wrong, I accept, but please see the statute.
Mr. Luthra, we are not going into that question.
My lord, your lordship will have to see which is the correct body. If it's not the guard, if a new body is created under the statute,
1 minute, Mr. Luthra.
it's a statute.
1 minute, Mr. Luthra. The Right of Persons with Disabilities Act 2016, when it says of Constitution of so and
My lord,
so,
this is the
is 1 minute, Mr. Luthra. It's for a different purpose. The purpose over here is because somebody has to represent the child.
yes.
Yes.
1 minute. Somebody has to represent the child when it comes to acts on his part. 1 minute. As far as Guardianship Act is concerned, as far as Guardianship Act is concerned, that will be proceeding before them.
My lord, allow me now, just see section, please see, Lord, 14 allows appointment of guardian under this act.
No,
Please just see it for a moment.
No.
Please see it, Lord. Lord,
Especially for
and
cerebral
Lord,
palsy.
please see, not for patients, children with cerebral palsy. Please see the law for a moment.
It is the guardianship court.
Please see it. Please see it and the Delhi High Court has given, division bench has given a judgment on this. The High Court ki hai na?
yes,
The
Kindly.
detailed judgment of the Delhi High Court. Madam, this statute.
It doesn't apply.
I've got the act and the rules and the regulation.
I'm sorry?
Who can apply to this?
Kindly have section
Parents
14.
or any
Parents or any
relative.
relative God.
We have-
1 minute, please.
There are rules.
If the father,
He can apply.
But he is disqualified under
Disqualified.
he's under this act. 1 minute. Under this
Being a
act,
foreigner.
just 1 minute, let me tell you, Lord. My lord,
So is
there
the-
is section 1314 of the act, read with rule 1713A of the rules, says that a guardian only has to be a citizen of India. This section was challenged before the Delhi High Court.
Someone else.
Delhi High Court in a detailed judgment
We've given
has
it over.
upheld the validity of the section.
Just on your lordship.
I had applied under this act to the committee. The committee examined my application and rejected it, saying that he is a Swiss national. The child is not an Indian national. He has a Swiss passport. So therefore, the committee said, you go before the guardianship act.
How many has-
Court.
that order is now final.
No, I have gone against that.
Fine.
I was.
And then as long as that order stands,
My lord,
we guardian.
Guardianship gratefulness.
We, however, clarify. We, however,
Let
clarify.
maintainability be decided by
My lord,
the
just
court.
allow me one thing.
Because
We, however, clarify.
My lord, will you?
Just 1 minute, please. We, however,
Just
clarify.
section
We have not
14, 15,
examined.
17, my lord.
My lord
Just
is
see, Lord, just see third, just see 14.
Could I just show section 14? The application of the act is not there. It does not override the guardianship
Lord,
act.
just-
Kindly have section
just
14 with
14.
me for a minute.
Appointment is guardian. Please note, a parent of person or disability or
Kindly have
relative
that.
may make an application.
There is a
It's a parent or a relative.
there is
Yes.
We are,
Now,
just listen.
there is a division bench judgment of the High Court saying this will override the guardianship.
1 minute, please. There is a judgment in this case which will operate as res judicata because it's saying,
Subject to High Court examination.
correct. We are clarifying that, that's not.
An application
Your
is
rate is
pending on our
pending.
behalf. Our application is pending in the.
Maybe it will be governed by the same order.
So, my lord, my writ against that order is pending
Let it-
coming
let it
on
be pending.
19th February.
We have not examined the question of applicability
That's fine.
of the rights of person. This one. Right, we have not,
No, Lord. This will be the National Trust for Cerebral.
Okay, we are not-
Palsy.
we have not examined the applicability of National Trust for Welfare of Persons with Altruism, so and so, so
Where
and
is that
so,
one from?
Act nineteen
And
ninety-nine,
the rules framed there.
and the rules framed thereunder.
Rules and regulations.
Rules and regulations framed thereunder. Full stop. This issue will be examined, is stated is pending examination and a writ petition
Before the Punjab and Haryana High Court.
before the Punjab and Haryana High Court.
We can wait.
Stop.
Not the LLC application.
We clarify.
Kindly be also be adjudicated
One
in
minute,
time frame.
We clarify that the observations made in this order and the earlier order dated 25/10/2024 are tentative and prime facie will not be treated as final finding, as already recorded above, be open to the guardianship court to modify, to vacate, modify, or amend the said order.
That's
Any time bound,
We
frame.
also request the guardianship court to take up the proceedings for hearing expeditions. Now, what about his expense, boarding, lodging, and traveling expense?
We'll speak to him. Not two requests I had to make. The Lordship had on the last occasion given a direction the child will not be taken out of the country. That may be continued.
That continue.
Assets belonging to the child will be alienated by
Alienated
the
also.
the next hearing. So
But secondly,
you have to clarify that.
The interim order, we did not. We have said that the order passed earlier will continue, will include the fourth of.
The funds are how the child is maintained. But if they say they are not.
Please go to the court.
Let them.
Please go to the guardian.
Yes, not let them.
Will be paid an amount of, please, how much should we pay? That towards fee, and in addition, the petitioner, the applicant, Sushant Sharma,
My lord.
shall pay for the travel and boarding and lodging. expenses.
Very
Grateful.
grateful.
My lords, just the
that.
time bound framework for the guardianship court, my lords. That's imperative for us.
Boarding and lodging, they not here.
Not my friend.
My lords,
My lord,
my lords, as regards the guardianship court.
Would my lord,
With your lordship.
time period, my lord. Would my lord
Indicate
indicate a time
time
period,
period.
because the guardianship court has asked for.
We request the guardianship court to take up the matter for hearing expeditions.
My lord,
My lord, any-
my lord, may I just,
Hence, my lords.
my lord, just one
Some
request,
time
my lord.
period, my lords.
My lord, just one request.
Single objection.
There are proceedings also pending before the LLC for the same purpose. My lord may direct.
Mr. Gupta, LLC will be bound by the first order. And they'll have to wait, we'll have to really.
Then allow this, that parties before the LLC can raise all their objections.
We are.
My lord may make that clear, because it.
We have said about the writ petition pending.
No, lord. What I'm saying is
My
that.
lords,
They are
Here
asking
before the-
for bar admission certificate.
Just a minute, sir.
And
Just a
the
minute, ma'am.
Just, I'll add.
Here before the
add one
LLC,
more-
not can't be ousted.
I'll add one more sentence.
Yes.
We also
Our
observe,
for the.
1 minute please, we also observe that the directions given above will not in any way deter any other tribunal or forum where proceedings are. It will not deter any other tribunal or forum from passing appropriate orders in accordance with law where proceedings may be pending.
Great.
and my lords, no technical objections now on porcelain, my lords. That's something, my lords, that's something which. It's been coming time and
After
again.
everybody has died, he has not, I have lived with the child. I lived in the same house in the next room.
No,
For 15 years, I never
Just
saw
some
his face in the house.
observation on that.
maybe please, Mr. Patwalia.
I'm not saying that
He
he's
did it, he did it because of the mutual consent they
Yes,
had.
yes.
He was paid. Mr. Patwalia, do not raise that argument.
No, I'm not raising it. But the point is.
The fathers,
He will.
look what, please, the father's right, bonding is certainly there. You can't argue
That's
against
okay.
that.
My lord, we leave it at this point, we leave it to find that there are certain issues on the father's conduct which are.
Next case, please.
Unfortunate.
My lords, no technical objections.
The
That's
apostolate,
one line, my lords, on
bar
apostolic,
admission,
etc.
membership of advocates. These are the things being asked for by the courts, my lord. This is what's been, my friend here.
Last time we asked him to get his.
I am, counsel for, please.
If a lawyer files an affidavit claiming as an attorney, not.
Why? Because that's normal. Abroad, it's normal.
Not here.
Please,
But the-
normally, please, it's normal. All the foreign companies also do it. If you look at the firms, they're all doing it. All your legal firms are doing it.
IPR, sir.
IPF firms are doing that. Don't be under that impression.
No, that's
Just that observation.
We also clarify that we also observe that the response will not raise any technical objection with regard to nomination, so appointment of attorney by the petitioner.
Grateful, my lords,
Very
grateful.
Grateful. my lord.
Grateful, that's all. Fair enough. Grateful, deeply blessed.
That we should consider to
Take a.
granted करके appellant and very possible.
My lords, in this
You
case,
challenge the rule in that, and the challenge is absurd. Pending writ petition challenge is otherwise absurd.
my
No
lords,
question of violation of separation of powers.
my lords,
But I won't comment on it. You file, amend the writ petition.
my lords, the writ petition, there is one more writ petition already pending. before
Correct, I'm
Gujarat.
saying you amend that writ petition.
My lord,
But your challenge, let me put it, your challenge on the ground of separation of powers doesn't hold water.
my lord,
But we'd rather not
Gujarat
comment on it.
court has declared itself as a police station.
Yes,
The
let
entire
it be.
investigation is-
Let it be. It's like similar to that for the purpose of investigation. That's all.
My lords,
So that they can record the statements, etc. Makes no difference.
my lords, then
And here, the principle of separation of powers has got no application.
my lord, then at least my writ
Move amendment. That's all.
at least that my writ
That's-
petition will be heard along with the other matters which are pending.
Why don't you move an amendment application and the other writ
My
petition,
God.
is all we are saying.
It was already dismissed. The other writ petition was in context of disciplinary proceedings.
Correct, in
Not
that-
in context of criminal
Correct,
That
proceedings.
context, this question arises, is it not?
It does not arise.
You are challenging these rules which have been implemented while passing that termination order.
My lords, there is some confusion. I think the learned
No, please,
counsel.
you're confused. We are not
My
confused.
lords,
Let me put it very clearly. There's a writ petition, you have challenged disciplinary proceedings, correct? In that proceedings, that writ petition, please move an amendment application impugning the rules and regulations. That's it.
my lords, that writ petition was disposed of. Only a review is pending qua that writ petition. So now in review, I mean, my technical difficulties, how would I amend the writ petition?
When was it disposed of?
My lords, that was disposed of on 6th February 2024.
And when was this writ petition preferred?
My lords,
This also was filed after that. After you failed in that writ petition, you filed this.
when that was disposed, my lord, that was a separate
After
issue.
that.
After that, my lords.
You filed it
This
after
was
the writ
filed on
petition was,
1st April.
after the writ petition was disposed of, you
Yes,
filed
my
that.
lords. Yes, my lords.
Um,
1st April 2024, I filed the fresh writ petition.
See, and there are already writ petitions challenging the same aspect pending in those courts.
Yes, my lords.
Okay, then tell us why is the rule bad?
My lord, so far as the rules are concerned, one, the investigation is being conducted under the direct supervision of Honorable
Correct.
Chief Justice.
That's correct.
Now, Honorable
No, it's done under the vigilance branch. That cannot be.
Vigilance.
We cannot have a separate wing conducting the investigation.
My lords, in all other high courts, in any matter concerning a judicial officer, it is the ACB which would have control over
Who is ACB?
investigation.
What is ACB?
My lords, the Anti-Corruption Bureau and
sorry.
Prevention Corruption
No, sorry, you're wrong. You're mistaken.
would go, okay, my lords.
You're absolutely wrong.
Prevention
That
of
will be-
Corruption Act.
That will be rewriting the provisions of
My
the
lords,
constitution.
other
It's
high-
always under by the High Court.
the PCA has a specific section with regard to investigation, my lords. Then the
No,
Prevention
sorry.
Corruption Act,
Sorry, please, cannot be.
my lords, at least then liberty may be given to me to file.
No, please, there's nothing in that. You challenge to the rules is odd. Just a hyper-technical challenge. It has to be in the High Court itself. The whatever disciplinary committee, the opinion given, it goes to the disciplinary authority. Then it goes to the full court. The full court approves or disapproves of that. It's not within the Chief Justice's domain.
But my lords, also the criminal proceedings.
Let me find the writ.
If my lords may just have the rules for a moment. My lords, the rules say,
Let's see the rules.
yes, my lords. My lords may see appendix. My lords may have page 83.
Yes,
Rule 16 and 17, my lords.
yes.
Rule 16 says High Court of Gujarat shall be declared as a police station as contemplated under the Code of Criminal Procedure, having jurisdiction over whole state of Gujarat, and the vigilance inspector shall be the officer in charge of the police station. Then 70 says no other anti-corruption agency in the state shall have any.
Correct, rightly so. But this is with regard to the investigation which is done for the purpose, and then they'll file the charge sheet. Because they don't want police to interfere in the judicial functioning. Because the moment you ask the police officer to come and interrogate you, it lead to difficulty. That's right.
Then, my lords, the mind of the sanctioning authority
No,
would
it's not.
already be prejudiced.
No, please, nothing doing. nothing there.
Then,
That's not so.
since two petitions are already pending,
Let it be, let it.
if the question of law is ultimately
We are leaving the
decided-
question of law open, but there's nothing in it. We are not inclined to interfere with the impugned judgment, and hence specially petition is discussed.
My lord, the question of law may be kept open.
The question of law is looked over.
Much obliged.
May I please the list?
Yes, please.
Well, as High Court had wrongly recorded that it's pending since 24 years. As a matter of
One
fact,
minute,
this,
please.
this
When was the writ petition dismissed or disposed of earlier?
2008.
And when did you file the second petition?
Yes, yes, I just thought so.
Miss, tell me the date.
The High Court.
When did you file the second? Thereafter, when did you approach the writ court?
That's what I'm saying. When I filed my representation, the reconciliation was done.
To file the second writ petition.
He filed it after this.
Well, that's the,
After this.
but
hearing-
just kindly allow me.
He filed it after.
Kindly see page 37. They accepted my all reconciliation all this while. And
Mr. Balbir Singh,
I'm sorry.
the difficulties from 2008, when did you respond?
Yes,
After
immediately.
2008.
Kindly see
Right.
page
How many letters were written between 2008 and 2022?
20 letters. 20 letters. Kindly see page
But
37.
Did anybody wait from 2008 till 2020?
Because they accepted my reconciliation.
But
Please-
by one letter of 2022.
No, multiple letters. Kindly, that's what I'm saying. Page 37. Only page 37. They called me multiple times. I submitted record again and again. Kindly see page 37. Letter of six. I'm sorry, page 3737.
But that letter is of 2022. Any letter
Yes,
before
yes.
that?
Kindly see.
Any letter before that?
Yes. Kindly, I'll read out of it only. Sir, that's how the letter.
I've gone through this letter.
Please kindly see. They asked me when I filed my representation.
Some sort of it, no?
Has gone to the letter dated 6/12/2022. Written by the respondents. Full stop. It is accordingly submitted that notwithstanding that it is accordingly submitted, the writ petition should not have been dismissed on the ground of delay and laches. Issue notice returnable in the week commencing 21st of April 2025. My only concern is the petitioner may not have got this letter deliberately written.
No, I can.
1 minute, Mr. Balbir Singh, this is possible.
I have attached the additional.
No, it's quite possible.
I will show. It's a. They called me
From
reconciliation.
2008, when the order is passed, till 2022, there is no correspondence.
I'll
And
satisfy.
which sensible person will write a letter?
I'll show that. It's not 20 letters. I'll show that, Malaj. I'm grateful.
There's 215 days delay.
Yes, these are letters which we got from the department, which are in the additional paper bit to show
You
20
not-
letters.
These were not filed earlier.
Before the High Court, there were 3 letters which were there. Other letters which we got from the department. And that's why there is a delay, Malaj. The additional letter showing that, Malaj.
Okay, with both in the application for condemnation or delay and the special. Item 4 will go before another bench. My brother cannot hear this one. To be listed before a bench presided over by Mrs. Patiwal. The week commencing 24th of February 2025.
Item 5 minutes, I quite see the delay, but otherwise.
1 minute, please.
David,
What is there also in this? There's
Otherwise-
nothing in it.
There was a.
You can yourself extend the time. I've never seen a state behaving like that. You are autocrat or what?
Because of COVID.
No, please, you cannot. You can't. I'm very surprised that you've been asked to pay 6%, you should be asked to pay 18% interest.
I'll leave it at that.
What a stand taken by you.
I'll leave it at that.
We do not find any merit in the present appeal. In fact, the stand taken by the state of Jharkhand is absolutely incorrect and contrary to law. Accordingly, we dismiss. How much is the delay?
24 days.
Accordingly, we dismiss the application for condemnation of delay and the present special leave petition. Absolutely wrong. Yes, please.
Whether the conduct of the respondents amount to an oppression and mismanagement, my lords. And this, my lords, the court.
When did you
below-
file the petition?
Please,
When did you file this petition? When did you file this petition?
my lord, this was filed 2012, my lords.
2012.
And this was pending. There were many.
One
other
minute, 1 minute.
petitions.
Now, as far as your removal, etc. is concerned on merits, do you have some point? The reference to the civil suits which are never entertained is of no consequence.
That's right, my lords.
You have a point there. And all that reference in the judgment is therefore of no consequence because none of the civil suits were
In
maintained.
all the criminal cases against me, I got acquitted also.
The criminal cases, no, there are complaints against you under 138, etc. But your removal, etc., otherwise is right. Why you can't be always removed by the company?
I am the founder,
Name?
director, who has innovated the entire company, my lords, and,
No,
and everything was.
no,
the
no,
entire
you
company was
can't.
built
You
up.
can't. Otherwise, you don't have a case on merits. Why should we even entertain it? So otherwise, on merits, you don't have a case.
My lords,
Because the fact of the matter is, you gave those checks bounced. 138 complaints, you yourself
no, my lords, 138 have been acquitted, my lords.
correct? Maybe you may not have pursued it properly. May not have pursued it. Who wants to get on with so much
My lord,
litigation?
the question which my lordship will look into is whether it is burdensome, wrong, and it's against probity and good
No,
conduct, my lordship.
you were removed.
My lord,
No, no.
then my lords may kindly permit me to withdraw because there are other petitions which is
Okay,
pending.
learned counsel for
Liberty
the
to agitate, which is permissible.
learned counsel for the applicant seeks permission to withdraw the present appeal and states that the petitioner may, if advised, may pursue on, which the petitioner has filed other proceedings which are pending. Stop the petition, the appeal is dismissed as withdrawn. We do not make any comments on the effect of this order on the other proceedings.
Please, my lords. Deeply obliged.
May I please
The respondents on a caveat.
apologize for making this request, my lords. May I seek 1 week's accommodation? As led by the ASG in this matter, he is not in court today.
There's why was so much delay?
No, the petition is not maintainable.
Why?
The tax effect is below the 5 crores. Petition is not maintainable apart from 400 days delay for which they say nothing. Would my lord just see in the.
Otherwise, it does, there are two reasons given by the court.
Yes.
I couldn't understand the Delhi High Court judgment because Delhi High Court judgment, in fact, partly supports him.
My lord, they have followed Delhi, which is approved by Supreme Court. Magnati Marelli has been followed. May I just explain on the merits?
दूसरा पेज कहाँ गया?
In case we have to issue notice, we don't require. In case we not issue notice, we'll adjourn. crores.
We have written it as 51 crores, but I can verify that.
Manoj,
I can-
may I just show you in one moment? He's picked up the figure. 51 crores is the total royalty paid by the company.
That's wrong.
That is wrong. Please see the High Court's order.
10% is the rate of
We'll
royalty.
verify we'll verify that.
But no, what is the difference between the royalty paid by him
And the
and
adjustment,
and the
11 crores 95.
and the amount which you have now computed in
11 crores 95. Manoj, may I make it good from the papers themselves? I'll make it good in one moment.
Let him check up on that.
Very, Manoj, 11, just
Let him check up on that.
difficulty, let him check the tax effect number 1. 398 days delay, number 2, no reason given. I'll leave that. There's 400 days delay. The Delhi High Court decision, which is followed by Bombay, what does it say? Magnetic.
We have seen that.
Yes.
We've gone through that. We discussed this.
Follow.
Let him come. Let him come. At the request of the additional solicitor, relist. When do you want next week?
Any day.
Relist in the week commencing 24th of February 2025.
Very great.
The petitioner will examine the tax effect as it is stated that the tax effect is below ₹5 crores.
24th, week beyond 24th.
But the week commencing 24th, it will be listed. It is week commencing.
Grateful, grateful.
Very
Election Commission.
Is correct. In item 8,
Please, my lord.
tell us one thing. Does the Election Commission have the power to go into the question of rejection of nomination forms under the Act?
My lord, the election commission would not have the powers, my lords. It would be the election tribunal only, my lords.
So then, in that case, the order is correct.
Please, my lord, we are only, my lords, I would be seeking only a journalist to approach the election tribunal and within a time bound, my lords, the election tribunal may dispose of my case, my lords. The general order that the court is passing, my lords.
Okay. But the order doesn't say you can approach the Election Commission, Election Tribunal.
My lord, the order does not say, my lords.
It is declared the candidate elected.
It is open to the petitioner to approach the Election Tribunal as has been directed in other cases by this court, including special leave to appeal C number 30413 of 2024. Most of the directions given in the said order will equally apply. According to aforesaid, the present special leave petition is disposed of with liberty to the response to approach this court if they are agreed by the order passed, by the observations in this order.
Please, Your Lordship. This is regarding the impugned order passed by the High Court, determined referral.
1 minute. Now, there are 3 agreements, all on the same stamp paper.
There are 2 agreements, my lord.
3.
2 agreements.
There are 3 agreements. Come to page 21.
Yes, my lordship.
All are dated 3/10/2021, 2011. The first agreement is subject matter of arbitration application number 217 of 2023.
Yes, ma'am.
This has signatures of everybody on all pages.
Yes, ma'am. Yes, ma'am.
Correct?
Yes.
Then the second agreement is, and it's executed on sandpaper bearing serial number 7032. 3-2.
Yes.
In this case, reference has been made to arbitration.
No, my lord. This has not been.
Even in this case, that reference has not been made to arbitration.
Only with respect to 217, the reference has been made to the arbitrator, my lord.
217, that's what I'm asking you.
217, the reference has been made.
Okay, now the other two agreements or the other agreement, there is no signature on the first pages, first 3 pages.
Yes, ma'am.
Correct?
Yes, ma'am.
And in the last page, there is signature.
Yes, ma'am.
The witnesses are the same, which is the, okay, let's have a look at the agreement, which is subject matter, to 217. Let's have a look at that.
Yes, ma'am.
Don't use photocopy. That
We do photocopy of it.
be the same in all the 3 cases.
I would like to explain.
And it is possible you have taken the last page of the first agreement and interpolated that. It will be a criminal offence in fact.
I would like to clarify on this point.
It is a criminal offence in
No.
fact. How can the stamp paper number be the same?
The respondents are the main contractors, my lord. They buy the stamp paper and they sign.
Sorry, will not accept that.
My lord, if there was a real forgery and fabrication, till now the respondents have not taken any action.
No, please.
They are not.
You have the photocopy of the 3 agreements. Show us that.
Right now we don't have.
I'm quite sure the last page will be the same as the first one. If you look at the photocopy, it will be the same one. What you have done is where you have signed, you have put it and next it along with the others.
Kindly allow us to file the photocopies, my lord. My lord, at this stage,
We should have thought about it earlier.
one kind submission, my lord. One kind.
First case they made the reference, that's correct. We're not inclined to interfere with the impute judgment and especially petitions. Yes,
The
please.
scope of interference with the arbitration award is limited. My lord, the arbitrator has been passed.
No, in this case, you are in a mess now. There's a clear decision of this court that as far as insurance policies is concerned, it's only the quantum of the dispute, quantum of the amount. And that was a problem in Vidya Dularia I faced.
Can you see? The law laid down by this honorable court, my lord.
All that you can do is revive your suit. I agree with you, it's a mess, complete mess, because Section 8 application being filed by the bank was allowed, revision petition is dismissed, but it's a wrong order. It's a complete mess.
Can you see?
In any case, the second award, the award it was passed was filed by 2, not by 3.
Well, you can't consider. But the law laid down by this honorable court recently also that the scope is limited.
No, please. 1 minute, please. Vidya Dolaria refers to 2 judgments of this court,
please.
Both authored by Justice Khanvilkar.
Please.
In arbitration matters saying you cannot go into. Number 1. Number 2, as far as 34 is concerned, second look as far as existence of the arbitration agreement and whether the scope, whether the disputes are covered by the arbitration agreement is not covered by public policy. It's a full review.
Please.
You're wrong. 34 talks about full review.
Can you say the intention of the legislature?
No, please, only thing we can permit you to do is revive your suit, civil suit.
Please, my lord.
That we'll do.
Observe, my lord.
Because otherwise you'll be left remediless.
Please, my lord. My lord, the consisting view, my lord. My lord, consisting view of from Ambika.
We do not find it good ground and reason to interfere with the impute judgment. But do observe that the petitioner may be entitled to revive his civil suit, which he had filed. Revive his civil suit number 4B of 1997 for recovery of rupees 24,12,500 in view of the findings recorded in the impugn judgment. So if any such application for revival is filed, the petitioner may rely upon section 43 of the ANC Act for the said purpose. If any such application is filed, the same will be considered part of the law.
Great.
Recording the process, especially petition is discussed.
It's item 11, Milords. My claim is both against respondent number 1 and 2, Milords. In fact, the letter of intent, it is my case, has to be read along with the minutes of meeting, Milords.
Tell us one thing.
Yes.
As far as Sterlite Technologies is concerned, there is no arbitration agreement.
Milords, in the...
That's one.
That's right.
If you turn to the memorandum meetings at page 44.
Yes, Milords.
And then there in page 44, there is no arbitration agreement. In page 47, is there an arbitration agreement?
There is an arbitration agreement, Milords. I am denying this letter of intent, Milords. This was only... Plus, this letter of intent was subsequently issued to me. I am only relying on the arbitration clause in the main letter of intent, Milords. What my lord looking at is
2017. One minute. This letter at page 20th May is denied by the other side.
20th May is denied by me, Milords.
You're denying it.
I am denying 20th May, Milords. I am placing reliance on the first letter of intent.
Oh, then you'll have to go for a civil suit.
No,
that's the reason is you're making a claim against both.
That's right, Milords.
You're not making a claim against one.
That's right, Milords.
Therefore, it will be better for you to go to KHANNA Holdings, will therefore apply. You cannot now bifurcate the causes of action, and neither can you bifurcate the number of parties.
Milords, my claims are not interdependent, Milords.
No.
Page 44.
No, please, sorry. You'll have
Milords,
to
the
go
document which my lords looked at page 44, Milords, incorporates, it makes a reference to the earlier LOI.
No, but that will not be. That will not be.
Milords, may kindly look at paragraph 11 for a
Don't complicate the matters.
Honorable High Court has said.
We have seen that. Don't complicate the matters. Once you are accepting that letter at page 47 is denied by you.
Milords, my claims are not interdependent, Milords. At least why?
But yeah, so what's your
respondent number 2, Milords, my arbitration claim.
No, please. Once you file a common claim, then you file. Then KHANNA Holdings coming to you.
Grateful, Milords.
We're not inclined to interfere with the impugned judgment, though not for reasons mentioned therein, but in view of the judgment of this court in the case of KHANNA Holdings, or just remonitor. In view of the judgment of this court in KHANNA Holdings, give the citation. We are not inclined to interfere with the impugned judgment and leave it open to the petitioner to take recourse to appropriate proceedings. And
would my lords mention including a civil suit, Milords?
I said appropriate proceedings.
That's right, Milords. Grateful.
Madam, 29 days between file.
Item.
That I appear for the petitioner.
Yes, please.
And the delay is on account of the factor that the legal service committee was approached, and it has been pending from September 23 onwards.
Makes no difference. Let them. Only thing is, you should not tell them to sell the vehicle. It's already sold. It's already sold.
No, the order is in the teeth of subsection 3 of section 9 of the Act.
Leave it.
Let kindly permit me to withdraw and then avail the remedy, whatever is available.
Remedy you have.
Kindly permit me to avail the statutory remedy, my lord. It's an appealable order.
Seeks permission to withdraw the present specialty petition and says the petitioner requires will take recourse to appropriate remedy as may be available law. So with petition, the specialty petition is dismissed as withdrawn. Now we clarify we have not made any comments on whether or not any remedy is available to the petitioner.
In the meantime, delay may be condonable because it was pending.
No.
Let September 23 onwards, committee was holding the file.
No. Where is the question of delay? Once you withdraw, where is the question of delay? Yes.
Deeply obliged.
We should impose.
Your Lordships, I'm not even challenging that. Your Lordships, my pleadings itself say that I'm not basing a challenge on merits. I'm conscious of my limitations. I am the limited request before your Lordship says.
How much regard to application and a writ petition?
Sorry, Your Lordship.
Execution application and a writ petition.
That's right, Your Lordship.
So now that is what we are converting to 26 into.
It's a degree, in fact, it's a.
I am on behalf of the state, Your Lordships. This was filed by.
This state. 1,000 rupees.
No, then he has a point.
Your
Your
Lordship, the limited request that I'm making, Your Lordships, I'm conscious that.
Normally, it should be interest should have been 18%. That's why I was saying here.
Yes, Your Lordships may kindly.
$50,000, how much? 3,50,000 you have to pay?
Your Lordships, according to them, 8,10,000 and.
Or 8 lakh, you know.
Your Lordships may not. Your Lordship may dismiss the SLT. I'm not saying no. Your Lordship may kindly see para 10. The Honorable High Court has said that 50,000 will be recovered from the officer concerned per month.
Contempt dismiss?
Your Lordships, the contempt was dismissed by virtue of an order passed on page
And when did you
92,
make the-
24/5/2023.
When did you make the payment?
Your Lordships, I have made the payment before that. In fact, the breakup Your Lordships will find on page 100. Your Lordships will see these 4 items. The question before Your Lordships only with regard to interest.
Contempt will be only maintainable in case there was a specific direction fixing the time period.
Yes, Your Lordship, which is why they filed an execution application.
And there is contumacious conduct, deliberate conduct not to decide it. Because in this case, you virtually accepted the payment have to be made.
I did not challenge the order on page 74. That's right, Your Lordship.
You did not challenge the
I did
order.
not.
You did not challenge the order to page 74. You accepted the payment has to be made. Probably you don't have funds. So you did not have funds. So and the payment got delayed by about 7 months or
10 months.
10 months. So in that context, the court felt that 6% rate of interest will be rather low. So made it 50,000 rupees a month.
Yes, sir.
That means what was the total amount payable by you?
Your Lordships, it's in excess, it's between 8 to 9 lakhs. Yes.
Total amount, principal amount payable.
Your Lordship's principal amount was actually quite a lot. 35 lakhs, 8 lakhs, 8 lakhs, and then 27 lakhs. Page 100, Your Lordship will have the breakup.
58 lakhs, they've asked you to pay about for 10 months, 10% rate of interest instead of 6% rate.
Yes, Your Lordships may kindly.
Instead of 6.10%, what difference does it
Your
make?
Lordships, it will be going from the officers. That's the only thing.
Go from
Kindly
the
see
officers.
para 10, Your Lordships. That's the only limited plea that I'm making before the court.
Pay it, 30 pay.
Your Lordships will pay it within 4 weeks, but not from the pocket of the officer.
We are
not even contesting.
We are not inclined to interfere with the impugned judgment and leave the question of law open. Regarding the first of further, we clarify it will be open to the petitioner to decide whether or not to recover the amount from the concerned officer after undertaking necessary inquiry.
Very well. Highly played.
According to the opposition, the special petition is dismissed.
Your Lordship may just stipulate an outer limit, then which they can comply, and I'll inform the department that they have to pay within 4 weeks or 3 weeks, whatever.
What you have paid immediately?
I have told them, Your Lordships, but
pay them immediately.
If it comes from Your Lordships, that
No,
is far greater bearing.
Payment will be made immediately.
Very well.
Payment to the respondent will be made The petitioner will now make payment to the respondent immediately.
Highly obliged. Grateful to your lordship.
This, I may mark it before another bench. I don't know whether I had earlier recused from this matter as a judge of the High Court.
Not to my recollection.
No, I had.
In fact, my lord had in the case of
So the bench presided over by Justice J.V. Padiwala, the week commencing 3rd of March 2025.
May it please. Item 15.
Yes.
My lords, the High Court proceeds on the 15th.
Now tell us one thing. What is this voucher which you give?
Yes. Now what happens, my lords? Exporters who are performing well are given money equivalent scripts by the DGFT. They are given the scripts under the foreign trade policy. For in this case, it's 2015-20. They are akin to money. So what happens, my lords, when
then when you took out the circular, it was dealt with this purpose only.
Sorry.
Was it not? The language of the circular is it's in terms of that only.
No, so it
But
is.
1 minute, please. The circular was to deal with this specific situation.
Exactly. So what happens?
So, but then you should accept the circular.
No, so
now, why are you turning around now?
So in fact,
why are you reconsidering it?
They have followed the circular. And the,
No, 1 minute.
Just
Please, you're wrong. No, you're wrong on that.
Look at page 50.
Yes, my lord, it's the.
How it's worded. You grant an exemption.
Correct. Now what happens?
You don't say that the duty will be paid by way of those scripts.
But my lords may see page 50, the first line.
The exemption, that's what it says.
This issue, for 1 minute, this issue must have only arisen in case where the SSCs were using the scripts.
Yes, in this case, that's
what. And that's the reason why you issued the circular.
Absolutely, my lords.
So then when you issued the circular, you were cautious of the fact that some SSCs will be using the script and claiming there is no duty payable.
So, well, the script is equivalent to money. For example, 100 rupees duty is paid.
Then you ought to have said that the duty will be payable by way of the script.
Which is
not what you said.
But which is what
you said hereby exempts goods when imported against a duty credit script.
May I pass on a copy of the bill of entry? I have.
No, please read that. Please read. The circular was very specific.
Absolutely, my lord.
Your circular said, in case you use a script, zero duty is payable because of the use of the script. We will not collect the social development fee.
Because, my lords, the script is debited with the duty, therefore don't pay cash. That's the understanding of the circular.
But read your circular at page 50.
My lord is right. That's at first.
That's not how it's worded, though. You seem to understand it now differently to suit your convenience.
No, even the.
No. It's the board itself taking a different view now.
SSC
going back on your promise.
When he imported the goods, they have paid the money through the script, my lords.
We do not find any good ground at least to interfere. We are not inclined to interfere with the impugned judgment and especially petitions.
Wait. No, we went for a review. Against the review judgment, it's
okay.
The issue is whether a writ is maintainable against the award passed under the
That's
MSME.
pending.
And your lordship said.
Just tell us one thing. In this case, what was the dispute? But tell me one thing. Why don't you go for 34?
No, it is time barred.
No, it is not time barred.
Yes.
You had filed a first writ petition under 32 before this court.
Yes.
You turn to page number your writ petition, which is enclosed at page 89.
But your lordship has referred the matter to larger bench.
I'm aware of that, please. But please come to that. But otherwise, you will be under 34 within the limitation period. Just come to that. Come to page 97.
Yes,
The Supreme Court, there is no such similar pending, except CA which was withdrawn with liberty to file a petition on the same cause of action while order dated 1/4/2024. And thereafter, you filed the writ petition before the High Court on 9/4/2024.
Yes.
Correct? And what's the date of the award? Is October 2023.
Yes, ma'am.
What's the date of the award? 19th October.
Yes.
So if you exclude this period in terms of section 14,
Yes, sir.
will you not be within limitation?
Well, but the
One
problem.
minute,
Yes.
Mr. Sanghi, let's be very clear.
Yes, sir.
Even if we say the writ petition is maintainable, it will be maintainable only in few circumstances.
Yes, ma'am.
Not in all cases. It will not be the same merit review, or even the scope of review will not be same as in 34.
Yes, ma'am. But I have to deposit 75%.
Yes, you are right. But please examine one thing. In a writ petition,
Yes.
your review, because in this case,
Yes, ma'am.
what if you go through the award, you virtually accept everything.
Yes, ma'am. Yes.
Or merit, you accept everything.
I will examine, my lord. There are 2 more connected matters, my lord, pending. I will get it listed.
Not payable?
Not much, my lord. About 2 lakhs, 3 lakhs rupees.
2 lakhs and 3 lakhs of rupees. Then you go before.
My lord, there are number of. This is not the only writ petition, my lord.
Yes.
There are 2 more petition connected.
How much is the total amount?
Well, I will have to check. In other cases, I will have to check the amount.
Is it just 2-3 lakhs of rupees? Then why should we do it? When you have the adequate remedy, you can go under 34. Apply 14.
I'll check up and because there are other 2 connected.
Otherwise, you are right. We have kept the issue pending, but it will not be an open-ended thing.
Yes.
Writ petition will not be equivalent to open-ended thing.
Yes, I
It will be only on the grounds of writ petition can be entertained when there is an alternative remedy. In a special case, because it's statutory arbitration.
Yes, yes.
It is not a nonsense, and we have come across cases where there's some wrong orders have been passed by the council. You want us to attach it with the other one? We can do it.
Other 2, I said.
No, we'll keep it afterwards.
Yes, ma'am. Yes.
We'll keep it, let that matter be decided. Relist, and the request will counsel for the petitioner relist in the week commencing 24th of April. Sorry, 28th of April 2024. 2025.
Please. My lords, para 5, the High Court says that we have issued beyond 4 years. We have issued.
We have complete re-examination of same facts.
We issued within 4 years in this.
Maybe, but you can't reopen on the same facts.
No, but subsequent tangible material being the stat order, my lords.
No, please, sorry. Sorry.
Time of examination.
Sorry. You could have even without the SAT order done it. That's not tangible material. You could have, he explained you that I made a mistake. I did not pay that amount. And later on, I made a mistake. So therefore, he said this is lost. Don't make that. Just a year of when the deduction is to be allowed or expenditure is to be allowed. That's the issue. And we are not inclined to interfere with the impugn judgment and special petitions. Delay control.
May I please, your lordships? The question of law that arises in this petition, lordships, is it lawful and correct to saddle the petitioner?
You are the petitioner. You're lucky.
Lordships, I have been intimating time and again by way
No. There are 2 things. You could have. There's a bank which should be aggrieved by this one.
Lordships, as a matter of fact, my lords,
you can't. One more. There are 2 things. Under the law of pledge, which will be equally applicable to mortgage, a borrower cannot insist that the pledged asset should be sold. He cannot insist. Same principle will apply to mortgage. Same principle will apply to mortgage because you have to pay the money. You could have asked, you got a buyer for that money.
Execution proceedings may be expedited.
In fact, let me put it very clearly. The bank should be agreed by reduction from 10% to 6.5. Not you.
I leave it to your lordships. Grateful.
Better than all play. I to interfere with the impugned judgment and has specially petitioners dismissed. We have clarified dismissal of the specially petition will have no bearing on the petition, if any, filed by the respondent.
Well, it's in item 19. The order seems to be very innocuous, because the only difficulty is this. So far as my representation is concerned, that has been rejected by the bank.
Look, let me also, let me put it. People don't realize OTS are only accepted. When are OTS accepted? They are only accepted when the offer made by you is more than the value of the mortgage property. If the offer made by you is less than the value of the mortgage property, OTS is not accepted.
No, what I'm saying is, as far as the OTS has been proposed only because there was a mega OTS scam that was held by the bank, in which, my lords, this was the offer which has come from them. What, lordships, may I because this, so far as the representation is concerned, that was the High Court has, lordships, kindly, the only thing I am asking is this, my lords, the High Court has said.
Can't ask for anything.
Pardon, my lords?
You can't ask for anything. Let the auction take place, you buy it out there.
Lordships may then say one thing, at least the bank may dispose of my representation.
No, they have rejected your representation. Not once you say letter is not received. Very difficult to accept also. We are not inclined to interfere with the impugned judgment and especially particular discuss.
The impugned order says that you have an alternative remedy. And Manoj, no, Manoj, what do I do it?
What you do, you sit at home.
Manoj, I keep writing.
Pay the penalty then.
I keep writing.
No, you keep on writing, that's a lame excuse.
Inspection report is not to me.
No, doesn't make a difference.
Given to me.
Doesn't make a difference.
Cross is not permitted. Manoj, may I have this? Manoj, may I have this?
You did not,
I repeatedly write to him and
it's all nothing doing.
No, Manoj, may I have inspection? What reply will I file?
You
I'm not given the inspection report. I'm not given the
you file whatever you did. We don't have to tell you that.
reply without an opportunity.
Sorry, miss.
Without a seizure memo.
Sorry, not required. Just your conduct speaks volumes. Your conduct speaks volumes. File an appeal. File an appeal.
The circular categorically says.
File an appeal, Mr. Kaur.
Appeal I have to deposit.
Yes. 20%. That's all. 10% or 20%. No, sorry, Mr. Kaur. Deposit 20%.
Specifically said that alternative remedy is not a self-imposed restriction, but in a matter where there's a violation.
Mr. Kaur, if you want, we'll reiterate this is a case where you are marking time deliberately, not answering. No, Mr. Kaur. The show cause notice is so detailed, going into 200 pages plus. Speaks volumes of your conduct.
Say one thing, would your lordships permit me to withdraw with liberty to file the appeal and just give me some time to file the appeal? It should not be time barred. That's all that I'm saying.
You move an application for condemnation or delay.
That your lordships can say. That your lordships can say, my lord.
After some hearing, when the court was not inclined,
don't say that. Say that I'm withdrawing. Please don't say that. Don't finish my appeal, my lord.
Okay, right out. The senior advocate appealing for the petitioner seeks permission to withdraw this special petition. The petitioner states the petitioner will file an appeal within 3 weeks from today. Stop. He submits that the appeal is filed in the said period may not be dismissed on the ground of limitation. Next page. The petition is dismissed, the special petition is dismissed if withdrawn, with liberty is paid for. If any application for condemnation or delay is filed, the same would be considered sympathetically and according to the law.
I'm very grateful, extremely.
Well, there were 2 petitions. One is not listed today.
Same order in that.
There are different facts I'll point out. It's not
when
listed.
When it comes up, but one thing is very clear. This non-filing of reply, the show cause notices issued by the Customs and Excise normally are very detailed. And this is again very different. It's not a short show cause notice. It's not like the income tax department, 148.
Only one state.
Sorry.
Only one statement.
And normally, the order is passed almost 2 years after the show cause notice.
Well, they gave the time themselves after the order passed. I'll plead in my case, Malathi, let it come.
Grateful.
Your Lordship's order is at page 57.
You are appearing for the respondent.
Bali is connected online.
Who's appearing for the respondents?
We are, Your Lordship. I'm being led by Mr. Bali. He's
Okay, let him connect.
My lords, I will only say one thing. Had the respondents put us on notice, we would have saved a lot of time of the court. In fact, their facts are. Just one second. Notice means a legal notice, but everything is rectified. Mr. Soni will just hand over the relevant documents to your lordships. He would have told them that, just a minute, sir, whatever they require has already been done. And we have done more than that, my lords. Just kindly have one by one, my lords. So we should not be wasting your lordship's time, and we have totally abided by my lord's order, and there is no question that we will not abide by it. My lords, my name is, the petitioner's name is NIFD Institute of Fashion Designing Limited. Their logo was INIFD, Cradle of Designers. Now, my lords passed the order on the next day itself. My lords, I changed my logo.
Okay,
in terms of.
If you have done
Yes,
it, fine. Now he's done
I've done it. No. Further, sorry. My lords, my learned friend will allow me to speak. This is not only what I have done.
Lord,
Now he says, just a second, sir, allow me to speak. He says that I have not changed my website. My lords, I've changed my website. Mr. Soni, can you hand over the change of the website to my lords?
Website
I have changed. Just one second, sir. I have changed my email.
compilation that I have just handed.
Then he says, I have gone to Pune, I have gone to Ahmedabad. The billboard signs of the franchise are just showing NIFD. Well, there was a delay of 10 to 15 days by my franchises. I had informed them everything is changed.
Kindly see 3rd of February.
Everything is changed.
Fine. Now it's changed it, no? These are
Yes.
contempt in this case, like execution.
So had he told us,
In
my
fact,
lord,
we have already moved 39(3)(a).
Yes, exactly. That's what I'm saying.
39(3)(a). Probably even on 39(3)(a), they were not.
Absolutely.
Yes, Mr. Bali, let me put it. Your
Yes.
contention of not being put to notice does not merit consideration because he's filed 39(3)(a).
Yes.
So
But we have answered it there also. We would have answered him. And we would have called him for a cup of tea and asked him, what else you require, we'll do it.
This court, you realize that
No. We had already done it, my lord.
Order of High Court.
Right.
Order of Your Lordship's.
We have done the needful.
Let me see, an educator appearing on behalf of respondent states that rectification and corrections have been made and the responses are fully compliant with the directions given with the order dated
4th October.
4th of
October, my lord.
4th of October 2024.
Well, Lordship may clarify things.
In view of the aforesaid position, the present contempt petition is disposed of with liberty to the petitioner to file a fresh petition after due notice to the respondent in case he finds his violation of the
Lordship may record their statement that they will use expression NIF. This is what the option
yes, we have given.
Yeah, that's what we are using already. Grateful. It's deeply obliged. I'm grateful to your lordships.
Lordship, as per the office report, the second petition, which is reserved for order, raises the identical question. Powers of the board to levy the environmental compensation.
Pardon?
As per office report, 2 cases has been cited. First case is different because that is regarding the power of NGT to impose environmental compensation express builder. The second case is identically similar. The question involved is whether DPCC can impose the environmental compensation under 33A or 21A of WARA. This is same.
The judgment is reserved in that case.
It has been reserved in that case by Justice Narasimha.
In view of the submission made by the senior counsel appearing for the Pollution Control Board, he list after 4 weeks. Still pending? The High Court proceedings are still pending?
It is final order. They have allowed.
It's a final order.
Final order issued on the basis of interim.
Issue notice returnable. I thought they are still pending.
This is final order.
Issue notice returnable in the week commencing 28th of April 2025. Notice received by all, including thus. It is submitted that the impugned judge, in our opinion, the impugned judgment requires consideration. It is pointed out similar matters are pending and in fact in one case judgment has been served.
There is a delay of 15 days.
Lord. Next case.
Please.
Yes, please.
Sure. The issue on finding on possession, that is.
1 minute, please. Look, there is a debate. Let me put it. It does appear that you were given possession, free possession after they took over the position. They did give you a position.
Allow me to exhibit on that.
That's saying that we allowed them to hold 3 parties is all wrong because payment is also made by you. To that extent, there's a finding against you by the court. This is not correct because it appears 22nd May they took possession. They then allowed you to re-enter, and then in September they've dispossessed you. That's why you've taken off the newspaper articles are quite clear. July you also had weddings, but otherwise you are in default.
On that issue of possession, does my pleading convey the message that I am not in possession? That was to be seen.
But then you are in default of payment of debt.
This is a disputed question. But the court was incumbent to appoint else.
No, I'm saying in your favor. Why you?
I'm so sorry.
I'm rejecting their plea that and the finding in the order that is wrong. That's it. That's odd. So you paid the money, you held the weddings in July. That means you've entered the position, and the photographs clearly show that you are dispossessed in September.
Grateful.
That is in your favor. Why you objecting?
I'm sorry.
That plea of theirs is the make-believe. It is a case wherein you are dispossessed. They put the locks without taking permission of the court. They themselves put the locks and they threw you out. But then probably when you paid up the amount, they allowed you to re-enter. And then they took it back in September. But you have been at fault. You are not.
That fault has to be decided by the arbitration. These are all questions.
No, but Section 9 will not. Then Section 9 should not have been invoked. What is the state of arbitration now?
That arbitration has been invoked. The proceedings have to be started. Now I'm going to file associated.
You have not filed your claim.
Not yet. But the problem which is arising in this matter, there was a fit-out period of 7 months.
Filed an application for arbitration.
Yes, already appointed. Mr. Rafiq has been appointed as
Mr. Paul, let me put it. The story of yours that you just allowed him to hold the weddings for three weddings and he did not redeliver the possession is wrong. That finding is wrong.
His own pleadings say that he was dispossessed.
Yes, he says on 22nd, but you allowed him to re-enter.
Not dispossessed.
No, you took law in your hands. You took law in your hands by putting the lock.
Your lordships have time and again said that as far as the licensee is.
No, it's your license. 1 minute. Mr. Paul, this is not a license. Please get it.
A license. That's what is said. This is a lease. This is not a lease. His own rights are of a licensee under the Easements Act.
You may be calling yourself. You may be calling your.
This case has never been that this is a lease, not a license. In a license, my lords, the contract.
We are going to observe the findings recorded in this order will not come in the way of the arbitration.
Totally, this is one position. My lord, I have spent around 25 crore in the property. There was a fit-out period of.
I know. This license bit is odd. This is a charge. Again, somebody. It's absolutely a sham.
So it can't be that SLP and new cases. Some third party has taken over the property.
Right now. We are not inclined to interfere with the impugned judgment in view of the peculiar facts of the present case, as in view of the fact that we are not inclined to interfere with the impugned judgment and hence specially petition is dismissed. However, we must observe that some of the the findings recorded in the impugned judgment would not be binding on the the arbitral tribunal, which will re-examine the whole issue afresh without being influenced.
But I have a small request.
Without being influenced by the observation.
Great. Lord may provide a status quo till the time I find this.
No. It may be
destroying my item.
No, it may be contrary to your interest. Because the moment status quo is there, your claim for damages may go down.
Yes. Grateful.
You have a good case for damages.
Grateful.
Let's appeal to the High Court. I'm sure your lordships have seen the charges.
Should notice returnable. Please accept notice.
2-3 weeks.
No, please, we'll have to take them.
There should be a stay of it. He's accepting notice.
Okay. Issue notice returnable in the week commencing 28th of April 2025. Notice accepted by respondent. Sajid Pal Singh, who's present in person, and accepts notice. Reply may be filed within 4 weeks. Rejoined if any within 3 weeks after service of reply. Original records will be produced in the court on the next date of hearing. There will be stay of operation of the appeal judgment till the next date of hearing.
I will blame.
R4, the service of notice to be issued to respondent number 2 on steps being taken within 10 days. Notice will be served by all boards. Yes, please.
Please, Roger, 25 is a case where I had challenged my APAR before.
I know, but after how long will you challenge that?
Because this was never cumulative.
No, this is a sham. After the judges of the school. This Kajul's judgment?
Please, Roger, that was 2009.
After that, they have been doing it.
Please, Roger, you see, but they were not able to produce any proof before the court.
Same year you got the reward, or is that?
Same year I got 2 rewards.
In the same year you got the reward? Okay. Issue notice returnable in the week commencing 28th of April 2025. Notice will be served by all courts including last day. It is submitted that awards given for the same year in which the grading was, the award of best year is for the same year in which the above grading of the petitioner was downgraded. The respondents have also not been able to produce any material to show that downgrading was communicated to the petitioner.
In fact, the reporting officer had given me very good.
No, I know, we have understood that, but the very fact that you have the papers will indicate that you are aware of the grading given.
No, that I became aware.
Right on 22.
Because Normally what is happening is after Justice Karchu's judgment, in some parts of the country, my brother was saying some parts of the country it's not being followed. Some other parts of the country they started complying with it because Abhijit came thereafter. Abhijit reiterated that view, and there were then issues. I think Department of Personnel had issued also instructions.
Please, Lordship, because what they're doing in CAPF is that when they communicate the APR, they take acknowledgement and that they file in the APAR file of the employee, which was also missing.
They still say because
they have
after 5 years they have weeded out the file. That's what they're trying to do.
No, that they have weeded out the official records, but
you must have got your must have got your MACP by after 1 year.
No, yes, Your Lordship, I got after that period of 5 years got over.
5 years or 1 year?
5 years.
Next case.
Please.
Your Lordships, this is a case in which a blacklisted party.
No, blacklisted is fine.
Your Lordships, that
Done.
Your Lordships, it was from 20 to 23 was one. Which
1 minute. There are two aspects.
Yes.
When was the blacklisting order passed?
It was in August of 2020. I'll just give
August of
2020.
And it was valid from which period to which period?
It was for a period of 3 years, Your Lordships. It was for the period
10th August
2020 to 9th August 2023.
9th August. When was the tender floated?
Your Lordships, this particular tender was floated on 16th of October 2024.
16th of October
2024.
Now there are two ways to look at it. One is when you refer to anything blacklisting in the last 3 years, it can refer to the date of the order.
Yes. And
that date of the order is beyond 3 years.
That is one. But the
He did not disclose it.
Yes.
As far as the department is concerned, they were also not aware of it.
They were not aware of it. And which
1 minute, please. Who got the contract ultimately? R5 got the contract.
Yes, R5 got the contract ultimately.
And number one, you are not the lowest bidder.
I was the second. I was the second highest, Your Lordships. Next.
You're the right one. Or there was somebody else in between.
No, I was the second. There were only 3 parties who were finally identified.
Look, there are 2 ways to interpret it. One is that the order was passed in 2020.
Yes.
If the order is passed in 2020, the bar of 3 years will not apply because the tender was floated and given in 2024. A person is entitled to interpret the clause as he feels is more beneficial to him. You do it. So many times lawyers also do it.
Your Lordships, to which I only add on to state that it was not even the manufacturer of the tendered product.
Point.
Yes. The second important point is it is not even the manufacturer of the tendered product.
That's they have been trying to.
But Your Lordships, what is to be considered is that as far as SAIL is concerned, in their reply itself at page 144, they have conceded to this position that they have not even verified this fact. Because my respectful.
Now the contract is awarded legal.
And Your Lordships, also one more important issue which I may point out that I've been rejected also on a hyper-technical ground by the High Court. It has not dismissed me on this count. They are only saying that you have no locus standi.
No, we're not going to
But your lordships, my respectful submission is that there are public safety issues which are involved. These are conveyor belts.
Oh, they conveyor belts.
A person who is not even a manufacturer. How
most of the manufacturers are similar.
And it is arbitrary, your lordships. They are importing the products. That was our case. It is going to be dangerous.
Like to interfere with the accused judgment and especially in the process.
May I please, Lordship, my lord?
Yes, please.
One respectful submission, my lord. This is an MSME, my lord.
Yeah,
It is
so
very,
what?
very difficult, my lord, to even survive in that state, my lord. What has happened is, may I just show one submission, my lord?
You've been asked to deposit 50%.
Correct, my lord. I'm finding it difficult to deposit 50. May I just show one, my lord? Only one legal argument, my lord. Your lordship sees, my lord. This honorable court has upheld the RBI master circular.
We are aware, but
Yes.
that ultimately you don't realize the end result was dismissal.
My lord, all I'm saying is this. I want to pay. My lord, today, please see just one page, my lord.
You have been a defaulter for very long.
See page 22, my lord. Just one page.
You have been a defaulter for
My lord,
very long.
but please see page 22, my lord.
Sorry.
My lord, my only prayer is this. I need some time, my lord.
50% only you have been asked to deposit, not the full
My lord,
amount.
I'm only saying this. Please see page 22, my lord. Just one page. Only one page, my lord.
Sorry, please. Since when is the default?
My lord,
When is the default?
my lord, I set up this MSME in 2014. The bank advanced 2 crores to me in 2019, my lord. There has been a default, my lord. I am not running away. I'm only saying every scrap of property that I have, my lord, is attached. I am trying to, my lord,
Sorry, please.
gather funds, my lord, to pay.
That's,
My lord, please give me some time and reduce, my lord. My lord, because, my lord, this is a very fledgling, my lord, industry.
Sorry.
Trying to, my lord,
Sorry,
fabricate, my lord.
we do not find any good ground.
Your lordships kindly consider, my lord, extending, my
No,
lord.
no, please. We do not
My lord,
find
even
good
his
ground.
residential house,
Maybe
salary
please.
account, everything is
Nothing has come from 2019 onwards. Not a penny.
Get paid. It's
Not
not
a penny. Nothing. 50%. The amount was 2 crores and odd. Today it's 3 plus something.
It's 3 crores today, my lord. It's 3 crores today. Lord,
We are
I'm
not inclined to
requesting
interfere
for
with
some
the improved
sympathy.
judgment and hence specially petition.
Very well.
Next, please.
Obliged.
Please, my lords.
Yes, please.
Lord, this is with respect to the cancellation, my lords. The grant of bail.
Are you married?
No, my lords.
You are not married?
No, my lords. The child is from this very relation only, my lords.
No, no, no. But are you married otherwise?
I'm not married.
Your father Sikta claimed that you were married.
No, my lords. I'm not married, my lords. That the.
No, no. Are you otherwise married?
No, I'm not married.
You're single.
Yes, my lord.
But as far as she claims that when the father Sikta came there, that you already married.
No, my lords. I can put an affidavit to that context also, my
Just
lords.
come to page 25.
Yes, my lords.
It says the father of accused stated that accused is already married.
The accused is married, my lords.
He got married.
I'm the complainant.
But he's not.
I'm the complainant, my lord. The accused is married.
Please come to page 3.
Please, my lords.
The extracted order
Yes, my lord.
refers to your affidavit, which, according to the High Court, falsifies your claim that you were not aware of his marriage. So he was married before he got into the relationship with you.
My lord, subsequently, when I was in the.
You have not filed a copy of this affidavit. Whatever affidavit you have filed.
He preferred in my lords, anticipated. He himself is not placed, not consider one aspect, my lords. He had offered to.
Relationship for too long. You had a child also. Very
Because that
surprising,
child is
but
from this very relationship.
I know that. I understand
Yes.
that.
No, if
I
you-
understand that, but the factum is that you never got married, and it does appear that you were already aware.
No, my lords, it's subsequent. When I insisted to get married, my lords.
Cannot
then
be
Now,
so
my lords,
long
you
if
only
you're
consider
being-
one aspect, my lords. Now, there is a
Cannot
child
be.
with me. He had offered to pay some sort of money. My lords, you only consider that aspect because I have to take care of that very child. Only that limited point, lordship may consider that aspect because there is a girl now. Now she's lord 7-8 years now. He himself offered that money, but High Court has not considered that very aspect. He himself offered.
You move for the no cancellation of bail, you can move for under the 125, etc. You get your money.
Lords, then again, if your lordship may in this itself, because High
No,
Court
no,
should have
you're
considered.
not,
My
you're
lords,
not
now
going to her.
that's the
You're not-
only limit.
We're not inclined to interfere with the impugned judgment, but leave it open to the petitioner to take recourse to appropriate remedy in case appropriate remedy for payment of maintenance expenses, etc. Payable to the child.
I'm grateful, my lords. My lords, I must point out there was some delay in refiling, lords. That will be handled.
Note.
Grateful, my lords.
Wait, please. The question was whether, my lords, employees of the integrated coach factories are public servants.
What is called? To give sanction for prosecution.
The submission of the state is that there is no occasion for sanction. They are not public servants within the meaning of 197. There's a judgment of this honorable court which says that.
They will not be public servants.
They will not. May I just show them?
No, but the reason they have given for not giving sanction is something different. They're saying that otherwise they are not
appeal of the High Court order. Essentially,
they are not responsible for this. They are not responsible.
In fact, sanction appeal of the High Court.
No. They have said that they are not responsible, and therefore we are not. They are not saying that 197 will not apply. Look, they are conflicting judgments of this court. They are conflicting judgments of this court, and when sanction is required.
The statute, my lord.
My lord, I am appealing on behalf of Railway. We have filed a report. My lord has given us direction to submit a report whether sanction is given or not. So we have submitted. We have not accorded sanction because the problem was not their intentional as a systemic failure. Due to that, such incident happened. So Railway Board has denied sanction of the authority. So this is
Admit as leave granted to be taken up for regular hearing in the week commencing 28th of April 2025. This issue will require to be considered because the conflicting judgments of the court. When you say that the misconduct or the fault happened during whether it's within the course of employment or outside the course of employment. And in any case, this case, it was at in the factory itself.
Our Legal Contractors Act specifically, the liability is on the manager and the occupier. 92 of the Act.
My lord, our concern is
continue the interim order.
Interim order to continue.
I'm so grateful.
Grateful.
Wait, please. The plea for suspension of sentence, my lord. Well, it's 1 year, 11 months around, since March 2020.
The last occasion,
we've seen the evidence. The father later on accepts, everybody accepts that she did not take the money and we made a false statement that she.
Manoj, that is so far as money is concerned, but so far as rape is concerned.
Please, one minute, please. It was consensual. The only question is of whether it's a statutory rape or not, because she was less than 18.
Please, my lords, for
and she became 18 within 1 month or 2 months thereafter. And the question of, I don't find any real evidence on the age of the girl. Where is that evidence?
Page 21, my lords.
What is that?
The mark sheet is there, my lords, and your lordships on
No, that's not binding. That's not binding.
My lords, on the last occasion, your lordship sees, your lordship wanted to see those judgments which say that juvenile justice act, whether it will apply or not, my lords. There are 4 judgments as recent as 20.
No, please, there is a difference between the inquiry, which is, if you read Justice Nagaratna's judgment and you read Justice Pardiwala's judgment, it's very clear. No, please, it's clear. It's very clear. As with Justice Nagaratna's judgment, it draws a distinction between the standard of proof when it is before the board and when it is before the court.
So, my lords, the standard of proof may be
different. No, please. No. For one month or something, 2 months, sometimes. It's a case of consent. It was a case of consent.
My lords, there's no question of consent, my lords. This is statutory rape, my lords.
I know that, but the question of age will be the issue. Right now, leave granted. Having regard to the facts and circumstances of the case, we feel that the appellant, Robin Meena, who's already undergone incarceration for more than 1 year and
11 months.
11 months, should be released on suspension of sentence during pregnancy of the appeal which is pending before the Rajasthan High Court, and it's likely to take long time before it is heard. And which cannot be heard within a reasonable time. Stop. Accordingly, we allow the present appeal and direct that the appellant Probin Meena will be released on suspicion of indictment of criminal SP criminal appeal number 792 of 2023 on terms and conditions to be fixed by the trial court.
It's confident to that. And the judgment was to be pronounced. He didn't turn up, so that has to be kept in.
The petitioner the applicant will give out the mobile telephone number on which he can be contacted while he is on bail. By the police officers while he is on bail.
It is already seized by them. I'll have to take a new number now because I've been inside for 2 years. And then
look, my brother tells me I didn't notice that fact. You absconded.
For some time, he was also 20 years of age. Lordship.
You are also 20 years old.
But 2 years now he has been inside. Under 342, etc., he has already served the incarceration for 1 year.
No, but then the other offences 10 years.
Others 10. For that only, Great.
This is very strange, Mother, that the sister then, after getting all the releases, after we having paid 75%, Mother, sister goes and files a suit and says that, look, there is a family dispute and therefore all these resolutions are bad. They are living in the same house, Mother. The sister-in-law, they're living in the same house, and the notice they say is sent in Calcutta. This is all collusive to deprive me, Mother, of property for which I've got part possession under 53A. We are running a factory there.
No, but the appeal has been dismissed.
Yeah.
Your appeal
on what ground, Mother? On the ground, this is all completely wrong. It's not even discussed.
The partition suit?
Nothing, that's still going on, Mother.
This property has been excluded from the partition suit. They have filed a suit for a specific performance.
That's right.
Which is pending. And one more thing, my lord, they have also filed a criminal complaint against a director with whom they have entered into this agreement, my lord. Those directors have been prosecuted, my lord.
Yes.
Now, my lord, we have been totally excluded. They have colluded with only one director, entered into this so-called agreement to sell, my lord. And, my lord, they have...
What's the date of agreement to sell?
My lord, the date of agreement...
No, agreement to sale is registered. The sale deed not executed. And that sale is registered, Malad.
Makes no difference. Let it be. Let it cut.
2011.
Yes.
1 minute.
30th of March 2011.
Who's in possession of that property?
We are.
They are in possession, Lord. The day one they entered into the agreement, they have been put into possession by the director who has been ruling the roost, my lord. Only one person was running the affairs of the company, my lord. No resolution, my lord, at all.
Was staying with them earlier.
I'm sorry.
They were staying with other directors earlier.
Yes, the same house. The sister-in-law is in the same house. And she says the notice was sent in, obviously, Malads, because they've got their bank, they were to give bank guarantees to the bank, they got them released.
They had also given, the sisters had also,
yes, they got them released.
The sisters had also given bank guarantees?
Yes, Lord, we have also given.
But was the bank guarantees released?
Lord, yes.
And how will you not be aware of that?
Lord, kindly see.
Somebody must have paid the money to get it.
Lord, the moment I had come to the knowledge of this agreement, I protested, I wrote to the bank, all these are part and
parcel. The payment has been made pursuant to the agreement to sell.
But to the bank, not to anyone else, Milan.
When did you file the petition?
But I filed it, my lord, immediately after coming to know of
when
it.
When did you file? I want the date. You say I filed it in
March 2011. 20th March, they filed for oppression and mismanagement.
Wait, when did you file it?
20th March 2011, they filed for oppression.
When did you purchase the property?
The registered agreement was, Malad's payment was made in March, last payment.
30th
March.
30th March 2011.
They filed in April 2011, Manoj.
April 2011 they filed it.
Yes.
Yes.
And the resolution to sell the property is in March.
The moment I get to know that there
No,
is
that's how they got their bank guarantees released, Malaj. For a petition, they don't challenge the resolutions.
Not participate in the board resolutions.
Not at all,
Because you said that
all.
But Malaj, that's Indo management, that's their problem.
No, Mr. Simple. The sale deed or the agreement to sell is March. They filed the petition in April.
After they got the bank release.
No.
Yes, they never challenged that resolution.
Mr.
Malaj,
Simple,
don't challenge the resolution.
that shows that they were probably in dark. But the brother has.
Malaj, the concept of Indo management is quite clear.
No, concept of Indo management will not apply.
Malaj, I'm sorry. Why will it not apply?
I'll tell you the reason.
Yes.
You are fully aware who are the directors. You are knowing that it's the private.
How am I?
It's simple. Nobody buys property like that.
I'm sorry.
Nobody buys property like that.
I'm sorry.
Property is owned by the company.
Malaj,
Go into full details.
I paid the bank. I paid 75%.
You have a cause against the brother?
Malaj, they got the bank guarantee released. How did they get it released?
The brother must have got the brother.
There is an EGM. I'm sorry, Malaj. Malaj,
in the EGM also they never participated.
Malaj, they have got 0.what percentage? 0.3%.
How much is their shareholding?
How much is it? 10%.
More than 10%.
Okay, settle it out with them. Pay them.
Yeah.
Pay them. Settle it out with them. Then they have 90% is with the brother?
Yeah. And other shareholders.
No, who are the other shareholders?
Family members. And they're all voted.
And how much is the shareholding of the brother? All others have all voted? Others have all voted?
3%. Others voted in the resolution.
No, Milord, only one director. Milord, as a matter of fact, nothing had happened.
Let him explain. How many voted in your favor?
90%. 90%. 90%.
90% voted in your favor?
At your Lord.
And 90% have voted and there is no dispute on that? Is it factually correct that 90%?
EOGM had never taken place.
What I'm asking a question, can I have that answer? I ask, this is something very strange. You don't ask the question, you don't answer that, you go on a different direction. Please answer the question. Is it factually correct that 90% of the shareholders have voted in favor?
No.
What in the EGM, how many shareholders participate?
My case is this, no EGM had taken place.
1 minute, please. Others have not questioned the EGM. How many shareholders are there?
But 4 groups are there.
4 groups.
Two groups belong to me.
1 minute, please. What is your shareholding?
But my shareholding comes to 10.91 something.
10.91. Other 2 groups are not objecting to the EGM? Are the other 2 groups objecting to the EGM, not objecting to the EGM?
This is the chart, 23 shareholders.
Are the other groups objecting to the stake?
Objecting because they were, as a matter of fact, there were 4 directors.
We are asking, are the others objecting or not objecting to the EGM?
They were not objecting because they were
correct.
party to that.
Mr. Simple, sit down with them, pay them up. It's a question of money. Right up. So, is your party there?
But yes, no.
And your party you want to go for mediation, but be open to mediation. You have lost twice. You're hanging by a very.
You can go for mediation, no? There is no difficulty.
Right. Conversation given by the court that the transport party state that they like to explore possibilities of mediation. Template order, parties to appear before the mediator. 20th of February 2025. List before the court in the week commencing 5th of May 2025.
32, I'm appearing for respondent 7. I'm seeking some time, first date after notice. I'm appearing for respondent 7, Department of Irrigation and Flood.
What is this? A authorized colony will not have sewage?
No. I have nothing to say on that, Lord. I only want to place the on record how much work has been done, at what speed it is going on.
We'll restore the matter, send it back to the High Court. Or who's appearing for the petitioner?
Yes, my lord. I am the petitioner in this matter.
Is the work going on there, Mr. Yadav?
My lord, rest in most of the part, the work has been completed in 17 and 22 and 25 also, my lord. But they have left only 2 roads near my house, my lord, intensely, and made the payment.
Give me 2 weeks time to place my reply on record, because
Order is incorrect.
No, it is incorrect, Lord. The work in the irregular colony is going on. It's almost complete, like my friend.
Okay, then we record your statement that you come, regardless of the fact that it's the Mafras colony, you're doing the work of sewage and water supply, and it's likely to be completed as soon as this.
Well, regarding the 2 streets that my friend is talking about, this comes outside the approved map of that colony. He says that it has now been registered by the DDA. The DDA is, we work under the Ministry of Urban Development on the approved maps. These 2 streets are outside.
Instruction.
My lord, this is not correct, my lord. They have laid the water pipeline, my lord. They.
At the request of Councillor Petlan, Senior Advocate appearing for the 7th respondent, the praise form is granted 3 weeks time to obtain instructions. Released in the week commencing 28th of April 2025.
This street has not been issued.
Which one? 33? 32. Huh?
No.
For condemnation of delay is allowed, and notice will be issued to the unrepresented respondents.
My lords, in item number 33, apparently my lords, R2 and R3 are yet to be served, my lords.
Respondent number 2 and 3 are being unserved. Issue fresh notice to translate unserved response or steps being taken in 7 days. Notice will be served down. You are paying for him?
For the state, your lordship.
You have to file, you want to file reply or you want to argue without reply?
We want to argue the matter.
Without
we can file the, we will file the counter affidavit, your lordship.
State of Gujarat is represented and they file the reply within 3 weeks. We join the defendant within 2 weeks after service. List in the week commencing 28th of April 2025.
38th of April. Okay. Much.
Yes, please.
Before the High Court.
Second. Six. Pass over.
Your Lordship, Your Lordship, we are led by Mr. Dewan in this matter. Beg for a passover. Blush.
Lord, 120 days your lordships have laid down, my lord. That's being followed. Absolutely no reason, my lord.
Proceedings now.
Now, so it is listed today, my lord, for 39(1) and 2 to be considered.
What is the suit for?
It's a suit for specific performance, my lord. It's before the Commercial Court. It's under the Commercial Courts Act. No objection in regard to that aspect has ever been taken. Being proceeded, they contest right from January, but they have to file their written statement only in November. High Court.
Serve your purpose if you official notice is going to only delay your matter.
My request would therefore be, my lord, let the
Look, even if right to file letter statement is taken away, they can still question you on the cross-examination.
Yes, let them.
One minute, they can question you in
Yes.
cross-examinations.
Yes.
Suit for specific performance cannot be degraded without evidence.
There is actually a method to why they have done this. Between their entering appearance and Lord finally filing their written statement, they have created a number of third-party rights on the land. That is why my 39(1) and 2 I am pressing.
Sure, notice returnable the week commencing 28th of April, week commencing 21st of April 2025. Notice will be served by all modes, including trustee. It is submitted that the written statement could not have been taken into court as the proceedings are governed by the Commercial Courts Act. Stop. Hence, reliance placed on the judgment in the case of Kailash versus Nanku and others 2005 4 SLST 480 is contrary to law. Should we stay the proceedings?
But if your lordship could stay the proceedings, but clarify that the 39(1) and 2 could be heard. Because I'll tell your lordships why he is continuously creating third-party rights. Making plots.
Meanwhile, in the meanwhile, there will be stay of proceedings. However, the application and the interim applications, if any, can be decided by the trial court.
I'm grateful.
Well, there will be stay of trial.
Please, Maharaj.
I'm appearing for the petitioners in item 36, Maharaj.
Yes, please.
Yes, Maharaj. It's in terms of
What's the matters coming up on the 19th of February?
my Lord, circumstances have changed.
That you have not also seen the film.
We've
You have only seen the trailer.
only a trailer itself.
You know, we don't know what exactly is. Let it come up on 19th, let it settle. Let it come up on 19th, let it settle. If there is need, you can come back.
I'm grateful.
As the matter is still pending before the High Court, and it's listed on 19th February 2025. We are not inclined to issue notice in the present special petition. However, the petitioner is given liberty to approach this court if needed.
Here there's some guidance from an earlier bench, earlier order which has been passed by this court, which essentially did two things. It's allowed intervention on the question of law and restricted the oral submissions to appropriate time limit. So I'm requesting something similar in our case as well. Your Lordship may go to the operative directions which are contained in paragraph 12, and then I'll come back.
Yes.
Bearing in mind the facts and outcome of the appeal would bear upon the claim of the appellant, where the considered view that the following order would meet the ends of justice. The request made by the appellant for impleadment is declined. Appellant is granted liberty to intervene in the appeal by urging such submissions on law as the appellant seeks to urge in support of the appeal, which has been filed by the first respondent. We record the assurance of senior counsel appearing on behalf of the appellant will confine arguments to no more than 30 minutes. No adjournment shall be sought. The impute order.
Why should we do that?
Yes, so I'll tell you why. Because the issue over here, this order appears to be incorrect according to us for two reasons. One is we are representing, my lords, all insofar as the solar power generators are concerned. Now the problem over here is that the CERC has made a determination which will have an impact across the industry. So they made the determination in the case of the appellant before the APTEL, which is fine. But if that gets crystallized before the APTEL, then it will become the norm across the industry. Now, there is a very important issue which I'll just explain to the court over here. As your lordship knows that if there's a change in law, the generator is entitled to recompense from the distribution company. Now, here there is a change in law. So there's no problem on any of that. Now, the DISCOMs came up before the Electricity Regulatory Commissions and said that a one-time payment for change in law is becoming extremely harsh. So therefore, please stagger it over a period of 13 years. So the CRC and the generators have accepted that. Now it comes to the issue of what is the rate of annuity. So the rate of annuity, as your lordships will see by the CRC, is 10.41%. And that has been computed having regard to the debt on the investment in the project. Now, debt is 70%, equity is 30%. Our primary contention and the question of law which we want to project before the APTEL is that this is an improper manner of computing the annuity disregarding the equity component. So that's the technical issue on which we wish to make submissions. And your lordship may confine us. I have in fact taken instruction that oral submissions will be confined to 15 minutes and we will file a written brief of 10 or 12 pages. That's all. But I don't want to be impeded. My request also, which is on record, my application, which you will find the prayer at page 141, is only to make legal submissions. Intervention, not impediment, and only page 141.
To be very frank, normally it's a list between the parties. It can be having a wider repercussions.
But Manoj, this has...
But does the principle of...
I'm sorry?
Does the principle of precedence apply there?
Sorry?
Does the principle of precedence apply to the APTEL tribunal?
Does the principle of precedence...
Yes, of course it applies, because what will happen... Okay, so that's what we have projected in our application. What will happen is that if this CRC norm comes to be accepted in terms of manner of computation of the annuity, then and upheld by APTEL, then all the other electricity regulatory commissions in a similar situation will apply it. So it has a sectoral impact, well, across the board.
Which file?
Of the impugned order?
Yes.
Yes, certainly.
Where the CERC's order is referred to.
Yes, yes.
And the APTEL's
May I read that change in law?
An individual order, which
Yes.
is not a common order. It is
No,
does not apply across the board.
let's be very clear. Let's be very clear. What your lordship says is absolutely correct. This is an individual determination of tariff in the case of respondent number 1 company before your lordship, which is ACME Bhiwadi Solar Power Private Limited. But what CRC has done while determining them, they have formed a principle. So the question of law which is going to arise, there may be several other questions, but the one I am interested in is just this, which is the appropriate annuity rate, because it will apply to all solar manufacturers. Sorry. Manoj, may I just answer your question? Just go to page 23, please. This is I'm only answering the question. The question is this not individual specific case of one person? Now, 23 has a full tabulated statement of 9 orders which have now followed the CERC order.
Issue notice, return and bill. Our attention is drawn to order dated, order dated
16th January. Oh, sorry, September. 25th September.
It was passed in a similar matter.
What is 16th January?
That's the issue. So, issue of office returnable in the week commencing. Where is the appeal listed?
Manoj, may I take Dasti? Yeah, next day. 28th of February. I'll take Dasti, Manoj.
In the week commencing. 17th of February 2021. 2025. Votes will be served by all modes, including Dasti. They will be given a short date, as it is stated that the appeal is listed for hearing before the APTEL tribunal on which date?
Dates before the APTEL.
The next date before the APTEL, I'm told, is 28th February.
On 28th February 2025.
Your lordship's returnable date is on?
17th, week commencing 17th of February.
Could it be 21st?
The timing is mentioned in the morning.
Friday.
2 o'clock, no?
What is 21st? No, I'm not sure.
Commencing that, let it be, it's a very short order, it's not very complicated issue.
No, it's not at all. No, it's just that on the 17th of February, if it's I'm not present. That's the only.
No, it will come up in the week commencing.
Oh, all right, very well, no problem. Okay.
Or you want it 21st, I'll keep it on 21st, but if suppose it gets.
No, that's all right, whatever. Your lordship.
The recommencing 21st, I'll make it.
No, 21st is I think a Friday. It's a Friday.
I'll have to make it on the week commencing then 24th, sir.
All right, 24th. Grateful.
Commencing 24th.
Lord, this is the matter I had mentioned in the morning.
We have not gone through the file.
Yes, my lord. My lord, this is by the wife. What has happened is, my lord, my client, my lord, he is a businessman.
Yes.
In December of 2023, he went to Dubai for work. He's taken a permit over.
How much? What is the case against him here?
Now, what has happened is, my lord.
What is the case against him here?
That's what I'm coming to, my lord. There were 3 complaints made by 3 individuals saying their PAN cards, etc., had been misused for registration of 3 fake firms, which have then undertaken business, and they have, my lord, there is a fraud alleged of GST evasion, of false claims. Now, my lord, how this is proceeded is, I am not in the original complaint.
Says, what is the date of the FIRs?
My lord, this is June. They are all of June
2023. So since 2023, you have absconded.
No, I have not absconded. My lord, I went with a valid document. I went in December 23. I've been doing business over there. I'm an Indian. I'm holding a passport. I have not heard from them. Not a single notice. My Indian numbers are working, my lord. I have not received any message from them. Then what happens, my lord? For business, I traveled from Dubai to Malaysia and from Malaysia to Indonesia.
When did you leave India?
In December 23, 6 months
since
after
then,
that.
Since then, you are not back in India.
I've taken a work permit over there. I'm working.
You come to India, we'll see.
I want to. That's my petition. Just allow me to complete what is happening.
India, we'll see.
Lord, that's exactly what I'm saying. I'm not asking for anything more. What has happened? Just allow me to tell your lordship the facts.
What is a blue corner notice, not a red corner notice?
No, it's not red corner. My lord, this is probably because just allow me, because your lordships have not read the file. So I went to Malaysia for work. From Malaysia, I went to Indonesia. When I land in Indonesia for the first time, I'm told there is a blue corner notice because of some proceedings against me in India. And my lord, they send me back to Malaysia. From Malaysia, when I want to go back to Dubai, they say, no, we will not permit you. Today, I am stranded in Malaysia. I am a diabetic. I want to come to India. They have in the meantime revoked my passport. With the result, my lord, I am stateless. Where do I go? All that I am saying is,
come back to India.
Lord, that's exactly what I am wanting. Lord, I am not saying anything more. Just kindly help me.
Give you a temporary permit to come.
Yes, that's all I want. I want to come. I'll join the proceedings. I'm willing to surrender before the court. No difficulty at all, my lord.
They cancel your passport. The embassy will give you a temporary permit to come back to India.
That's all that I want, my lord. Your lordship may say, I will come and surrender. This is my undertaking to the court.
No.
Let them.
You please come back to, they do that themselves. They have detained you in now in Malaysia because you are person non grata, because your passport has been cancelled.
So, my lord, your lordship may only issue direct.
Now what they'll do is they give you a temporary permit to fly back.
That's the only direction I want. Only for that limited purpose, your lordship may call upon the union.
What is the prayer in the level?
Lord, prayers may be broader, but your lordship may restrict it to that. I have said that this blue corner notice be set aside.
What is the difference between a blue and a red? What is the difference between a blue and a red?
That will not.
Oh, you're not
Red,
you have to be reported back. In blue, you have to be there at that port. You cannot go outside the port, and you have to go back to the country.
All right.
They'll take you here. They want to come back. They want you to come back here.
I'm saying I'm wanting to come back.
So then what's wrong with the blue corner notice? Nothing wrong.
No, I'm not. Very well, your lordship may ignore that. Your lordship knows that.
Then what? We accept your prayer in clear. Come back. You accept your prayer.
That's what I'm saying. Let them issue me a document and let me be brought, or let me come back, whichever way. I want to come back and join the proceedings. I'm not running away.
The meaning of this blue corner notice is that you will stay put wherever you are.
And at the airport itself, and you have to come back. So red corner probably you cannot be deported.
He'll be deported.
He'll not be deported.
No, with red corner he'll be deported.
No. Deported? No.
Probably this is what red corner, according to my lord, I have not quite frankly examined.
Red corner notice, you're deported. That I know. So blue corner notice, I have not come up.
Yes.
So then the passport has been revoked.
And my lord, I moved the trial court for cancellation of NBW because they have obtained an NBW against me.
Right.
Trial court says
it is submitted on behalf of the petitioner that the petitioner would like to come to, should be deported to India and has no objection in this regard. Stop. The statement may be, in view of the statement, we relist in the week of, relist on Monday or make it Tuesday. Relist also. So notice will be issued to the central agency to nominate the council who will obtain instruction. Stop. Copy of this order will be also can be also used by the learned counsel for the petitioner for making a prayer to the authorities in Malaysia that he may be deported to India.
You are incarcerated now in Malaysia.
I am held, not incarcerated, but by the Malaysian authorities, I am not allowed to enter Malaysia. And I am just being held there at the end.
Mr. There may be 2-3 more violations because your now passport has been cancelled. There may be violation of the Malaysian law.
Lord,
I don't know. There may be violation of Malaysian law because you entered into that, came into that airport after a cancellation of passport.
No, that I learned of it. I went to Malaysia validly. I went to Indonesia. At Indonesia, I am told there is a blue corner notice. We'll send you back.
Correct. I don't know whether it's
back to Malaysia.
You will be sent back to Malaysia.
Yes.
So I don't know whether you may have violated the Malaysian law. They insist that till the punishment of the Malaysian law is first met by you, we will not deport you. That's a no problem also.
Lord, he is a diabetic. He is being treated by the Malaysian authorities.
We can't issue directions to the Malaysian authorities.
No, we are not even wanting that. All that, my lord, what happened? I moved the trial court for cancellation of NBW.
He does not press for other reliefs. He does not press for other reliefs.
No, my lord, my grievance is also when I moved the trial court for cancellation of NBW. We were not there, therefore application.
Correct, right? You have been absconding.
Not absconding, my lord. I am saying I made a statement.
Could I come to India instead of going to Indonesia? What prevented you from going to India or coming to India rather than going to Indonesia? Could I come to India? But come next week on 12th of February.
Very excellent.
Prediction.
Who's appearing for the CBI?
But I just wish to take only couple of minutes, my lord. I've already filed my written submission. Only 4 paragraphs from your judgments on, my lord, 4 aspects which are bothering your lordship, my lord. Number 1.
You are supporting the petition or opposing?
I'm saying that the entire process has to go because the identification is impossible and the High Court was fully right. Only 2-3 things, my lord. There is a judgment compilation, my lord, which is emailed, and there is also a hard copy which I have given. My lord, first judgment is Krishna Yadav, where, my lord, your lordships have held that the entire process must go where the CBI inquiry was ordered. Your lordship accepted the report. That's, my lord, the first judgment in the compilation. That 94, my lord, Justice Mohan's judgment, my lord, as your lordship then was. And, my lord, your lordships have been shown this judgment. I'm not going to it again. Second judgment, my lord, of Chakradhar. That's the principle, my lord, where gross illegalities have taken place. Email. Gross illegalities have taken place. Then, my lord, there is no question of any grant of personal hearing. That is, my lord, Chakradhar principle, my lord, repeated again. Now, my lord, one paragraph which I want to read, my lord, is from Tanvi server, which your lordships are seeing. Kindly see the third judgment, my lord. This was the entrance test for medical examination, my lord, the recruitment of seats. Kindly come to para 20 of this judgment, my lord, which is at compilation, page number. My lord, this is the Tanvi server 2015 6 SCC 573. Kindly come to, my lord, para 20. And, my lord, it is between just 3 lines below placitum B. The sentence starts, my lord, we are conscious of the fact. I just want to read with your lordship permission. Read it like para 20. I'm giving you the citation. I've emailed it to you.
Citation.
2015 6 SCC 573. Kindly, my lord, 10th line from top. Just 1 line above placitum C, in the middle the sentence starts, we are conscious. My lord, your lordship got it? Just permit me to read these 10 lines because that, my lord, would have some bearing for your lordship's kind consideration. अरे उनको जजमेंट का वो दे दो ना citation.
Cited by me also. That's what
Please.
Yes, please.
We are conscious of the fact that every examination being conducted by human agency is likely to suffer from some shortcomings, but deliberate inroads into its framework of the magnitude and the nature, as exhibited in the present case, demonstrate a deep-seated and pervasive impact, which ought not to be disregarded or glossed over, lest it may amount to diversity of a proclaimed mechanism to impartially judge the comparative merit of the candidate partaking therein. If such an examination is saved, merit would be casualty generating a sense of frustration in the genuine student, with aversion to the concept of examination. The possibility of leaning towards unfair means may also be the ultimate follow. Now kindly see the next, my lord, sentence. Even if one undeserving candidate, a beneficiary of such illegal mechanization, and next 2 words are important, though undetected, is retained in the process, it would be in denial of the claim of more deserving candidates. At present, the examination stands denuded of its sanctity and not possible to be cleansed of all the participating beneficiary candidates with certainty. We are thus on an overall assessment of the materials on record left unpersuaded to sustain the examination. So even one is undetected. There is a doubt. The process must go. And then, my lord, this your lordship may kindly come to the next principle, my lord, that if period has been spent, because the argument is that they have worked for 4 years, 5 years, 7 years, 8 years, so why should they be now en masse removed? My lord, in 2017, a number of, my lord, different views were being taken, and 3 judgments of your lordship, my lord, in the FCI matter, where, my lord, yes, the context was that the certificate with regard to, my lord, those scheduled tribes and scheduled castes had been found to be not fulfilling the requirement of the order to extend reservation. The judgment is in this compilation. Your lordship may kindly come to the judgment number 10, which, my lord, is 2017 8 SCC 670, and kindly come to, my lord, para 25 of that. I'm sorry, for para 24, which is, my lord, the printed page 698 of this judgment, and, my lord, this compilation 274. Kindly come to, my lord, placitum C, 3 lines above that quoted portion. 3 lines above quoted portion. The High Court reversed the decision and the appellant was dismissed from service. Before this court, the appellant inter alia sought protection since he had rendered nearly 27 years of service. So in this case, my lord, which was a batch of petition, 5 years, 10 years, 15 years and 27 years. And this is an earlier judgment, my lord. This is 2004 decision, which is, my lord, reiterated and approved by another 3-judge judgment by Justice Chandrachud as lordship then was. And, my lord, each paragraph dealing with each judgment gives the duration. And, my lord, therefore, the court said that the concept of the appointment being void will be applied. And therefore, what duration you have spent is immaterial. Now, my lord, there was a doubt again. And then, my lord, it went to another bench on 4 years, where, my lord, your lordship will get that judgment by Justice Parthivala, my lord. 322. This is Satish Chandra Yadav. Entire law is discussed again. And I just wish to, my lord, your lordships, I wish to show the last paragraph where, my lord, this argument of 4 years, etc. have been put in service. Kindly come to 106. My lord, the judgment repeats, my lord, up to the law laid down in FCI, analyzes FCI of 2017, and, my lord, on the facts of that case, kindly come to para 106. So far as the connected appeal arising of so and so, filed by so and so is concerned, the same also fails on the same very line of reasoning adopted by us. The only difference in the case of appellant is that he had put in 4 years of service before he came to be terminated. So time spent is immaterial. The concept of appointment having been obtained illegally and void appointment, therefore that will not be a factor to be kept in mind by the court that they have spent time. Now, my lord, therefore, if for the appointment has to go, number 1. Number 2, no hearing is required to be given. Number 3, time duration is not to be seen. Kindly, my lord, now come to this small compilation which I have handed over. 3 authorities were before the High Court. Now, my lord, this test. Respectful lord. Now, my lord, in 136, your lordship considering, my lord, the judgment of the High Court, whether the High Court has wrongly applied any principle laid down, my lord, I just wish to take 10 seconds of your lordship, my lord. The first criteria is, are there any gross illegalities? If there are gross illegalities, then generally, my lord, generally, the entire process must go. And that is, my lord, by server principle, my lord, which was in the case of, my lord, admissions.
Limitation.
Which is on admissions, my lord, in the MBBS courses, the court now adopted a principle that even if there is a possibility of not identifying even one person who has illegally gotten admission, but they could not get detected, the process must go. My lord, I had the occasion to save that process. My lord, I was appearing for the government and CBI, and my lord, these were admissions to the, my lord, counseling which was to take place for MBBS admission, and the effort was why everybody should suffer. So the court said, even if you are not sure about one, the process must go. Then, my lord, that as I had already said, my lord Chakradat, no individual hearing is necessary, and FCI we say no period. No period should impact the court. Now, the next submission which I am making is, my lord, is there any default or a defect in the learned High Court not following your lordship dictate? The principles not followed. If principles are not followed, the general rule is no interference under 136. And now kindly see what the High Court does. High Court asked the three authorities first. Can you assure me that this list is final? Kindly come to follow paragraph 242. Now I am only giving the responses which were specifically asked from these authorities. They got recorded in the High Court judgment. Please see the approach adopted by the High Court. In my humble submission, it is absolutely the approach which needs to have been adopted in compliance with the principles your lordship have laid down. 242. If your lordship may have my note, my lord, I have given the relevant line. I can go to the judgment, but it would save time. The first authority who's asked is SEC. Are you sure about the number of the people who have illegally obtained it? In course of para 243, the relevant line, in course of hearing, SCC did not discount the fact that possibilities of further illegalities are there. Then kindly come to 272, before I read 273, kindly come to the next page, para 265. I'll come back to 273 later. Kindly come to 265. This was SCC. Now please see what is the stand of the state. Para 265. State government therefore has accepted there were widespread illegalities in the selection process and that the number of persons who received appointment illegally could not be determined with exactitude. So the SCC raised hands, state raised his hand. Kindly come to the previous page 273. Last line on the page number 2, my lord. SCC at no stage of hearing claimed that it was able to check all the records and be definite as to the number of illegality in recommendation made, but had limited itself to those figures as stated in the paragraphs above. In fact, reports in the form of evidence filed by SCC from time to time had always stated that they discovered the illegalities were brought to their notice by the litigants or by the orders of the court. And if it is left to them, they raise their hand in despair. We cannot find out. Now please see, my lord, the state says I can't find out. No number exactitude I can give. And my lord, the finding is recorded in para 269. SCC board and the state government have consistently stonewalled any query with regard to selection process and have not come clean with regard to the manipulation, illegalities involved. Conduct of three authorities during the course of hearing can be classified as anything other than being cooperative. These findings are not, my lord, there is no quarrel with these findings. This actually happened. Therefore, my lord, the High Court said, first of all, I must find out from these three authorities who are directly involved. Everybody is running away. They can't even be sure what is the number. They say we have not even been able to collect our record. We have not been able to verify our record. We cannot tell you. Then, my lord, kindly see what the High Court does. The next, my lord, from 320 onwards.
Yes, Father.
Now, these are the principles, the observation made by the Honorable High Court with regard to three authorities, non-cooperative and admitting that we have no record. Whatever record we have been able to see, we can't say with certainty how many people have illegally obtained it. Nobody can say it. High Court now, my lord, with this admitted factual position, applies your lordship principles, my lord, which have been laid down. Kindly come to para 320. These paras, my lord, I am relying upon. Your lordship have read many times. Only three I will read it. I have given it in the written note, my lord. Your lordship may kindly consider. First is 320. In the event it is impossible or highly improbable to shift the grain from the shaft. So please compare it with para 20 of Tanvi server. Even if one has illegally obtained, even if he remains undetected and that probability is there, quash the entire process. Kindly come to 326. The entire selection process is shrouded in such mystery and in such layers that it is difficult to fathom the quantum of illegality performed. And my lord, I am beseeching your lordship's indulgence. Please test these, my lord, observations in the light of the jurisdiction under Article 136. Is there any such a defect committed by the court, my lord, by the High Court, which, my lord, shakes the conscience of this court to interfere in the matter? Kindly see 329. Now, my lord, I had the occasion to appear in Assam case, my lord, where the OMR sheets, they disappeared, and, my lord, in the house of the chairman, blank OMR sheets were found, so that whosoever comes with money, it is again, my lord, blackened and pushed in. That is, and all appointments are quashed. Kindly see, my lord, 329. Blank OMR sheets have been submitted. Such candidates have been shown to record sufficiently high number. The exact nature of candidate fraudulently given the appointment cannot be identified, more so in view of the attitude of non-cooperation exhibited by SSC. There are other manipulation illegality in the selection process which have not come to light. And 330, since it is impossible to separate the grain, therefore we have no other option. Then 331, retaining appointees selected through such a dubious process would be contrary to public interest. 332, the selection process does not inspire confidence to hold that appointed persons have been selected in a fair and transparent manner. Persons submitting blank OMR had secured appointment amongst other illegality, and therefore, my lord, those directions are quoted in the note, in this note on the subsequent pages, and in para 9 onwards, my lord, the judgment compilation which I have handed over with those 4 paragraphs to be kept in, my lord, consideration by your lordship. Therefore, my lord, it is a case where the conclusion drawn by the Honorable High Court, in my humble and respectful submission, my lord, do not fall foul of any of the principles which have been laid down by this Honorable Court, which ought to have been applied, have either been not applied or wrongly applied. Therefore, my lord, your lordship under 136 will not, my lord, consider this case, but for only, my lord, quashing the entire selection process, and, my lord, the recruitment and selection to be made once again, my lord, so that no merit is compromised. And this colossal fraud which has taken place, my lord, is suitably dealt with by your lordship, my lord, by confirming the judgment of the Honorable High Court. That's my respectful submission, my lord. I am deeply applied. My great.
Your lordship, sir, I'm appearing for the candidates.
CBI.
Come.
What do you have to say?
Actually, in this regard, the first query that was put to us regarding the authenticity of the data that we had recovered from Pankaj Vans. Regarding that, on the last occasion, Mr. S.V. Raju had handed over a note, a 3-page note. If required, I have fresh copies again. I can just give it.
Can we have copies, please? Can we have some copies?
My lords, may we also have copies of the note?
Copy.
Yes, yes.
We have some. Can we have some more copies, please?
Lordship, it comes to the first page. Lordship will note originally the entire scanning process. the entire scanning process was originally done by NISA. NISA had given it to another authority, which was Data Scantech. Data Scantech was the authorized authority. Thereafter, those data was provided to the SSC. SSC had deleted those data as per their rules. The examination period was 2016. Evaluation was done in 17. This pertains to 4 stages of examination: Group C, Group D, 11, 12, 9 and 9, 10. Now let's see, when we asked NISA that please provide us the data, NISA said we do not have a copy of the data. Thereafter, we went to Data Scantech. From Data Scantech, we had recovered data from the deleted portions of the files. So we had this one set of data which we recovered from Data Scantech. The files were originally deleted, but we managed to recover those data. Another set we recovered from the 3 hard disks that we recovered from Pankaj Bansal. So we had 2 data to compare with. Now let's see, whenever this scanning was done, it resulted in 2 versions of the copies. If let's say comes to the first page, there is an image copy, which is an exact scanned copy, and another is a response code. If Lordship also sees in the impugned order also, a response code sample has been put in at page 238. If Lordship sees both side by side, the picture may be a bit clearer. Page 238 of the impugned order refers to a report of the CBI which was submitted before the Honorable High Court. In that report, we have also given details of the investigation, how the data was recovered and everything else.
Page 238.
238 of the impugned order. In the bottom, Lordship will see there is a table put in.
Yes.
This table is the data which is equivalent to the response code. So we had to match 2 forms of data. One was the image copy, one was the response code that we had recovered. Now let's see, we checked with the response code data with that of the data which we got from the panel evaluation. So we'll come to the reasons portion, which is on the next page, and I will go through.
No, I just couldn't understand.
Yes, Lord.
There was a scanning done.
Yes.
Now, sometimes the scanners themselves mark the papers.
Yes.
Depending upon the circles which have been plugged.
Yes.
In this case, that is not done.
Yes.
It is manually checked.
Yes. No, in computer generated checks. So that's why we got the response.
Computer generated AI check.
AI check.
So it was automatically you feed in the OMR sheet, you get the answer.
Yes.
You'll get the marks.
Yes, Lord.
It was not done manually.
Not done manually.
But there is discrepancy between the OMR data found on the hard disk or retrieved from the hard disk from DataScan.
Yes.
And the 3 hard disks which were retrieved or which was seized from Pankaj Bansal.
Those matches, Lordship.
They match.
Yes. That's why I come to the, if Lordship comes to the second page of my note, I will read that first. It will be easier.
So what do you mean by this? Response code, what do you mean by response code?
Response code is that table format which I was trying to show at page 238. That is the response code data. And another is an exact image copy once we scan an image.
Okay, fine. Okay, fine.
So we get these 2 at the time of scanning, 2 copies, image copy and response copy. Now this response code is used to validate the answers provided by the candidate.
Correct.
And calculate the marks based on the predefined answer keys corresponding to each question paper. This is done automatically. And authenticity, for authenticity check, then there is a stage where the scanned OMR sheets can also be checked so as to ensure whether the automated checks that was done through the machines matches with that of the scanned data or not. Then verification of the hard disk, and then I will come to the reasoning, Lordship. Why we say that the data which we got from Pankaj Bansal is actually genuine and authentic. The first is, as directed by the Honorable Single Bench of the High Court at Calcutta.
Yes.
I'm at the second page of my note, Lordship. The reasons, point number 1.
Yes.
As directed by the Honorable Single Bench of the High Court at Calcutta, the scanned OMR images retrieved from the seized hard disk belonging to Pankaj Bansal were handed over to the West Bengal Central School Service Commission. The WBSSC subsequently evaluated the scanned OMR images using the answer keys available with them. They had the answer keys.
An inspection of the scanned OMR images was arranged for candidates or parties who applied for such inspection in accordance with the court's order. Following the inspection, no candidate disputed the authenticity of the OMR image shown to them, asserting that it was not their own. These observation was also noted in the judgment, impugned judgment at paragraph 289. Then let's see the hash values. These are very important. The hash values of the data seized from Messrs. Data Scan-Tech Solutions responsible for scanning the OMR answer sheets of WBSSC candidates on behalf of Mrs. Naisa matched with the corresponding data found in the seized hard disk of Pankaj Bansal. So we had two data, the hash values match. Similarly, the response codes generated during the scanning of the original OMR answer sheets by Mrs. Data Scan-Tech Solutions acting on behalf of NISA were found to match the corresponding data stored in the hard disk seized from Pankaj Bansal. This relates to the modification date. Whenever a file is created, it will create a modification date. So the modification date of both of these data, the one from the Pankaj Bansal and Data Scan-Tech matches. Furthermore, the dates of modification for the scanned OMR images found in the hard disk sheets from Mrs. Data Scan-Tech Solution and Pankaj Bansal were identical. These modification dates also correspond to the period when the written recruitment examinations were conducted by WBSSC, thereby affirming the authenticity of the data. The differing dates of creation reflect the transfer of data onto a new medium, while the modification dates represent the actual creation dates of the original data. We also had the 65B certificate. We had produced those certificates before the Honorable High Court. Honorable High Court at this point has ruled in favor of the CBI.
Bansal data retrieved by you? The three hard disks?
Just a second. It was in September
2022. 16
Yes, 16 September 2022. That's reflected at page 242.
And when is the scanning done? Date?
The scanning was done way back when the examination was conducted, evaluation was.
Comes in the picture for the first time in December 2023. In fact, January 24 in the charge sheet. And
the scanning, initial scanning.
No, that is a big question. Anyway, let him finish. That's a big question.
Initial scanning is in the process of evaluation only.
Right.
Now, paragraph 6, what you've said.
Yes, Lord.
Please read paragraph 6 again.
Similarly, the response codes generated during the scanning of original OMR answer sheets by Data Scan-Tech Solutions acting on behalf of NISA were found to match the corresponding data.
Where did you get this information? From what we understand,
yes,
except from what was retracted from Pankaj Bansal.
Yes.
There is no other information available. The
Data Scan
Service Commission doesn't have any hard copy.
We had the data of the response codes data. So we compared first of
mirror images are not available.
Mirror images are not available.
So this response code is still available.
Yes. The response code data, one set we got from the Data Scan-Tech, one set we got from the hard disk of Pankaj Bansal. We compared both and the relevant modification time matches on the date on which the original examination had taken place.
Mark sheets of Pankaj Bansal data, you will have to show there were gaps.
Yes.
There were gaps and manipulation was done.
No, Pankaj Bansal data is the original data.
Original, that's the original data.
Yes, that's the original data.
According to you,
no tampering.
No, that has not been tampered.
No, no tampering on that data. That is the original.
Hash values. are as per the date on which the
original evaluation had taken place.
job was done.
Yes.
But the hash value should have undergone a change because a simple reason. And last year was the one who did that scanning.
Yes.
Yes.
Ni-
Yes.
Last year is the one who did that.
NISA actually gave.
But they gave it to them.
Yes.
But Pankaj, therefore, but then the hash values, whenever there's second copying, also will undergo change. So Pankaj Bansal is not the first copy. You also accept it's not the first copy.
No, I'm saying Pankaj Bansal is the second copy copied from the data that was available with NISA.
But when you copy,
It's the third copy, my lords. It's the third copy. It's NISA, Data Scantech, and then Pankaj Bansal.
No, NASA did not do it. NASA didn't do it.
NISA didn't scan.
I beg your pardon, my lords. It's SSC, Data Scantech, and then Pankaj Bansal, and on the my lord, regardless, the last case. Just on the.
Correct.
That's true. I beg your pardon, my lord.
Don't confuse us after so many hours.
That's true, my lord. My lords, just on the hash value, since the CBI.
Please, no.
It was the metadata of the hash value.
Join on this at my turn, but this goes to the root of the matter. This is crucial.
This is not evidence in the eye of law. They have to satisfy us.
Please.
This is crucial, my lords.
We'll not hear anybody like this. We have heard you at length. We have already heard you, whether it's evidence in the eyes of law, whether the Evidence Act applies, what is the effect of 65B. We've all heard you. Don't say that. Yes, please.
Now, Lordship, the first scanning that was actually done was done by the Data Scantech. That was the first authority. From Data Scantech, it has gone to NISA and then to SSC. NISA's one person was this Pankaj Bansal. Pankaj Bansal had copied the data, which we had recovered during a search proceeding. We don't have the.
Now, you have yourself about Pankaj Bansal also.
Yes.
Commented
that the hash value matches.
So, but you have also said that there were gaps because if you look at the Pankaj Bansal's your argument before about Pankaj Bansal, which has been quoted just by Mr. Manendra Singh, you have said over there that it is not possible to rely even on that data.
Judgment of the division bench.
That's as per the division later.
Division bench has come to that finding.
It's not possible to rely upon even Pankaj Bansal's data.
But from our investigation, I can only say this thing.
That you feel that Pankaj
that is the original data, that is untampered.
That
is what our investigation has revealed.
And that data matches with the
Data Scantech data.
That's the match.
Yes. And all of these matches with the same modification time.
But the marks which are appointments are not made in terms of that data?
No, not. That's why we say that there is a final tampering between the original data, which is the Pankaj Bansal data, and the marks and data which was subsequently put in and upon which all the appointments had happened.
So the data which is maintained by the SSC is tampered data?
Tampered data.
The original data, which is untampered data, is the data with Pankaj Bansal.
Yes.
Please. I'm appearing for the people who were excluded. They were they would have been in the merit list, but for the tampering, your lordships. So now, as per paragraph 335 of the impugned judgment, your lordships, various conclusions have been arrived at, and what was the irregularity and illegality, those have been succinctly set in over here. If your lordships will just mark para 335, subpara 8, small Roman 8, 9, 10, and 11, your lordships, 11 and 12.
335?
335, subpara 8 to 12.
Yes.
So there are 4 kinds of major irregularities. The first, your lordships, is appointments higher than the declared vacancies have been given in respect of all 4 categories. Number 9, appointments have been given to persons who were not even in the panel. Number 10, appointments have been given to the persons who submitted blank OMR sheets. Number 11, appointments have been given to persons after expiry of panel. And number 12, persons placed lower in the rank have been given appointment in preference to persons placed higher in the rank. So your lordships will see that these 4 irregularities in fact, at this time and distance, seem to be established. Because whatever SSC may say, it has come on record by way of investigation, by way of subsequent confirmation, by metadata, that the SSC data on basis merit list, on basis of which appointments were given, had these 4 categories included in that, which were illegally included. Then your lordships may kindly see, which is very important, is number 13, that the merit list containing the marks obtained by the respective candidates has never been published. For that purpose, your lordships, I had also indicated to your lordships the earlier order of the Honorable High Court when the entire scam had broken loose in the Honorable High Court. The Honorable High Court had ordered your lordships, by order dated 12/5/2022, which your lordships will find at page 396 of volume 3 of the compilation. Page 396, volume 3. Lordships need not refer to it right now. Suffice it to say that a direction was given that the merit list should be published. However, that was never complied with. Then your lordships, what happened was that with regard to the rules, because when the High Court went through the rules which were to be followed, it found that the rules had not been followed. And for that purpose, your lordships, if I may just refer to the rules your lordships will find at page 93 of the compilation of volume 1. A lot will turn on the rules, your lordships. Lordships may see that I'm referring to class 11 and 12 rules, and they are paramateria by and large of all the 4 categories. If your lordships will come to rule number 12. Now the rule number 12, your lordships will see, provides the procedure for the purpose of selection. And going by the Nazir Ahmad principle, your lordships, 1945 Privy Council, which has been consistently followed, Rule 12 had to be followed for the purpose of declaration of the merit list and the procedure and the method of selection. Now, if your lordships will see, if I may just draw your lordship's attention to Rule 12, that the Central Commission shall arrange for proper custody of all online applications which may be received by it against the vacancies. Central Commission, after receiving applications, shall prepare a list of eligible candidates for purpose of preparation of a computer-generated database of all the candidates. This is the preliminary stage, whether he is citizen of India, age bar, all those things. The admit cards for written examination shall be issued by Central Commission by any mode as may be determined by the Commission. Commission shall arrange written exam. Commission shall determine method of written exam, contents of papers, etc. Commission shall decide the procedure and the manner of conducting selection tests. Now the important part comes now, your lordships, which is sub-rule 6. After evaluation of OMR sheet or answer sheet of written examination, the Central Commission shall prepare and publish in their website with all details of the candidates to be called for personality test, category-wise on the basis of merit, marks of written test, academic and professional qualification, as mentioned in Part A of Schedule 2, in ratio of 1:1.4 of final vacancies. Sub-Rule 7. Central Commission shall prepare and publish in their website a merit list of candidates prepared category-wise on basis of marks obtained in, again, 3 aspects, your lordships. Then 8 is with regard to the proportion of 1:1:4. And then the proviso is important, your lordships, which is 1:1:4. And then subclause 10. Central Commission shall publish such panel and waiting list of candidates in the website of the Commission as well as offices of concerned regional commissions. Copy of the same will be submitted to School Education Department, etc. So the first merit list which had to come out Your Lordships, was with regard to the eligible people for the written exam. After crossing the written exam, again another merit list was supposed to be published with regard to persons eligible for the interview test. After that, a merit list of 1.4 of the number of vacancies, 1.4 times of vacancies, panel had to be made, Your Lordships. And then Your Lordships will come to Schedule 2, which Your Lordships will find at page 99. And this is how the candidates were able to identify the illegalities committed. Your Lordships will see that there is a categorical breakup given of the exams and the marks to be taken and the weightage to be given, which could not be tampered with, because the school exam, class 12 exam marks could not be tampered with. That was a fact, a hard fact, which SSC had no control over. So Your Lordships will see selection to the post of teachers of class 11 and 12 in schools shall be made on the basis of written examination, evaluation of qualifications of the candidates, and personality test to be determined by the commission in the following manner. So written examination is the OMR. The weightage was 55 marks. Academic qualification, including professional qualifications, weightage is 35 marks. And personality test is 10 marks. Now, Your Lordships may turn to part B. And how, Your Lordships, the weightage of clause B, which is the academic qualification, would not be a variable number. It would be a constant number, Your Lordships. Lordships will come to part B. And if Your Lordships will see the first row itself, the examination is school final or Madhyamik or its equivalent, which is class 10. Full marks out of 35, Your Lordships, 6 will be given if you have got full marks in your class 10 examination. If you have got 60% and above, you will be getting 6 marks. There is no discretion in this. Below 60 up to 45, you will be given 5 marks, and below 45, you will be given 4 marks. And then there is relaxation in education for reserved candidates. Similarly, class 12 marks, the weightage is very clearly given. So, Your Lordships, now what has to be done in this situation where we find ourselves, Your Lordships, where these 4 irregularities have been committed, which have been more than established. And considering the fact that this is not a criminal case, because a criminal case is pending with the CBI, that as far as those consequences are concerned, those will come. This is a matter now, how are we to balance all the equities, including what do we do with the 2016 selection, where these irregularities have come to light only 2 years after the selection has taken place. It was consequent to 1 or 2 writ petitions which were filed, in which this entire thing came out, where RTIs were filed, where the whole fraud had come to light. Now, since the fraud was discovered only 2 years hence, Your Lordships, then the Lazarus doctrine will again apply, and what has to be done going forward has to be seen, Your Lordships. As far as making a merit list is concerned, now we have to segregate tainted.
See, the difficulty is this.
Yes.
We don't have the original OMR sheets.
But CBI, yes.
CBI says that the data with puncture also matches with the data which they have been able to retrieve from Canada, deleted data from Canada. But still we can't authenticate and vouch for.
Yes, Your Lordship.
We can't authenticate and vouch for that this is the original one, because in the absence of the original mark sheets, the suspicion is now today, even to the extent whether these are the original mark sheets of the candidates.
Very well.
Whether these are original MOM data mark sheets of the candidates.
Very well.
Because so much is happening, there's so much bungling which has been done, such a large scale, vast scale. It's impossible to authenticate that.
I'll just respond to that, Your Lordships. Now, let us see what are the alternatives that we are faced with. The first alternative is what the High Court has done. You can cancel the entire selection. Your Lordships, 2016 elections, there were candidates.
And in this case, not only the problem is that,
yes,
the problem is, one, we take the data as it is available in CSE, collate it.
Yes, Your Lordship.
Match it with the consequential data. That would have been, if that was so simple, it would have been done. But today, date and age, when we have doubt on even Pankaj Bansal's data because the original OMR sheets are not there, then what to do?
Yes, Your Lordship. So I'll answer that because that has been deliberately done. The destruction is deliberate. Therefore, we have to go to the secondary evidence. So I'll just come to that aspect. But first, let us examine, Your Lordships, the option of cancelling the examination. What are the consequences of cancelling the examination? And balancing all persons.
You are not even selected.
Your Lordships, I'm not.
I can understand somebody.
Got it.
No, 1 minute, please. Others who have got it wrongly can be knocked out.
They can be knocked out, but then Your Lordships
Maximum case of the petition is knock them off. But don't pull down those who are not involved. But what you are asking for is step beyond that.
Your Lordships,
and if delay in latches applies to the other side, in your case, delay in latches will complete the house. What you are saying is, after you knock them off, whatever balance is left, please let us call into it.
Meritorious people.
How can but that
must well be the meritorious people. I'm just proposing.
And in a case where the merit list is already exhausted, the time for merit list is already, final list is already exhausted.
Bear with me because Your Lordships, as Your Lordships have said, this is not a simple situation. There are too many complexities involved in this. So how do we put all those complexities together and come to some solution which will take the best, all the best options can be examined, Your Lordships. So this is what I'm putting to Your Lordships, that as far as knocking of the entire selection is concerned, there are two big consequences that arise out of it, which are not permissible under Article 14. First, Your Lordships, is that as far as the people who were meritorious have a substantive legitimate expectation to be considered, because here we are not at a point of time where the case law with regard to you are on panel, you don't have a right to be appointed. But I have a right to be considered in accordance with my merit. So that right being a substantive right and substantive legitimate expectation, I can't be thrown out because SSC conducted it in a particular manner, did some ghapla here and there, Your Lordships. My valuable right, because my right to public employment is a very, very valuable right, Your Lordship, especially in the current economic circumstances. So given that fact, Your Lordships, everybody who falls into the merit list must be considered. Secondly, Your Lordships, if this whole selection goes, then what about the candidates who had appeared in the selection? Now, Your Lordships, we'll all be faced with an age bar. How do we then come with a systematic solution to that? If we are constrained by the age bar, now Your Lordships will see that there will be new candidates who will come into the newly declared vacancies. So what does a fresh selection mean? A fresh selection means that you continue the process from stage 2, which is Rule 12(6) onwards, you continue the process, because the people who had appeared in that selection must be the only people who should be considered for fresh selections, except the ones who are tainted people. The tainted people have to go out, Your Lordships, because the tainted people...
Understood. That argument is a little far-fetched, but understood.
Your Lordships, it's not so far-fetched.
That's saying that only those people who had earlier appeared should be permitted to appear.
Then what, 2016, this is after 10 years. We are not talking of a situation...
Correct, well, that's fine, but that's fine.
Ago, Your Lordships. Now, if we go for a...
That's always so when the merit list is exhausted.
Because, Your Lordships, the OMR mark sheets, as far as the OMR sheets are concerned, now, CBI, Your Lordships, has very categorically said that it has done all the data mining, it has done the metadata mining as well, and has come to the conclusion that these two, this and Pankaj Bansal's OMR sheets match. So whatever OMR sheets are contained in that, suppose there are say 100 OMR sheets which are not contained in that. So forget those OMR sheets, there has to be some collateral damage. Your Lordships, we are willing to take that collateral damage. But all the OMR sheets which are there on the Pankaj Bansal drive should be, a merit list should be made out with that, and the process should start from there. That is my humble submission for your Lordships. And I have one more thing to say, your Lordships, because this is not a problem just arising in this matter, your Lordships. Now, this is with regard to recruitments which are running into thousands and lakhs of people, your Lordships. This is as an officer of the court, I'm just submitting to your Lordships, because there are several.
Just one thing, for the CBI, you have concluded that few. Just tell us, what was the total number of recruitment paid in the 4 posts?
Total number is
20. We have a chart.
Mr. Jaideep Gupta, how many were total number of appointments in each of the posts?
around 25,000. Total appointments? The total appointments.
I will just.
25 not in all the 4.
And you have a breakup of all the 4?
Your Lordships, this we have culled out from all the various.
No, you don't do that. Let the government and the CBI tell us.
Yes, your Lordships.
You don't do that.
From
don't
there.
do, no, we lead to further confusion. So in all, about 25,000 appointments have been.
Yes, sir.
How many did you advertise as how many according to you were illegally made?
There are 2 categories in it, Milord. Our own record shows that there was what we are calling, Milord, rank jumping and out of panel, where we have not given a recommendation at all. Milord, those will not appear from our own records when we revisited the record. There is a second category, Milord, where there is an OMR mismatch. There, Milord, we don't have the record. We are proceeding on the basis of the CBI's finding. So we have, Milord, given a makeup.
It's a never-ending
process.
It will not show.
Volume 6.
They say 952.
I'm sorry.
Another part they say 152.
No, all this has been reconciled.
All
there is
just
no
to
difficulties
confuse.
of figures just now. So these 2 categories, Milord, are there. Whether, Milord, there are any other categories, Milord, your Lordship will consider, Milord, based on RT. Lordship, but Milord, we are able to segregate each and every category.
So 2 categories only. You yourselves are saying if there is any other category, I don't know, you may do it.
No, I know. I can, Milord, make that segregation. If you say, for instance, Milord, if your Lordship says that the last counselling is out of time, then how many people will be affected by that?
You can't go.
We can give that figure.
That figure you can give.
Similarly, Milord, we have now.
Now, there are 2 types of mismatch. One is where the marks in the Pankaj Bansal do not match with the marks available with you.
In my survey.
In your survey.
Yes, correct.
And you can't even say, to be very frank, whether your server marks are right or the Pankaj Bansal marks.
But I cannot.
Because you cannot say because you don't know.
Yes.
In the High Court, they say we don't know.
But please.
No, but
you don't know. But if you accept, CBI report says on metadata that Pankaj Bansal appears to be the original. But obviously the defense being taken, which will be taken by all your officers would be, my marks are genuine and Pankaj Bansal marks are not genuine.
That's right.
Please give me 10 minutes.
No, wait. Alright, Mr. Patwalia, I'll take away the tablets also. We do like this. It's not possible.
Now you can give us his 10 minutes.
No, we have heard you for more than 1 hour. 1 hour each. So why are you require? We are putting questions, we want answers. Please. We have to close it. We have got 1 hour more, we have to close it by 4.
There's an affidavit.
So I would take only 5 to 7 minutes, because I have really not made it.
1 minute, please, Mr. Gupta first.
So give me 5 minutes before.
Okay.
5 minutes for me.
Okay, fine.
I am standing by the CBI investigation.
4 minutes, my lord.
We are accepting it and proceeding on that basis.
You're standing by.
Lordship.
And they have segregated your lordship.
Okay, according to you, as per the charge sheets filed by you, how many have been wrongly appointed?
Lordship will kindly come to our written submissions that is filed in the Supreme Court. The data and figures are there. There are,
see,
yes, but we have given the exact figures.
Go by that.
That your lordships will find that volume 6, page 14 to 17.
Volume?
6, page 14 to 17 of the.
No, that's in the Supreme Court or the?
That's in the Supreme Court.
Supreme
We have filed a
written submissions in the Supreme Court.
My lords, to make things simpler, I have a printout which roughly.
No, let the CBI give.
It's already here on the screen.
We can't have five.
That we can sit with CBI and will not authenticate it, will not no difficulty.
Only authorities
Cannot come up with a-
not everybody.
Not good enough.
5,189.
5,189
out of 25,840.
5,189.
Yes.
You say that?
But that is only in case of AMR.
It's a
Got 240, the SSC admits, my lord, 240 paragraph, the SSC admits it is more than 10,000 and they say so far.
This
in their own affidavit, they say so far.
Mr. Rauf is wrong.
Where does this figure come up?
I tell your lordship, my learned friend is wrong because
it's your affidavit.
Statement taken from an affidavit of 2022.
So then this
where we said that this is what we have so far.
More than 10,000.
Now, my lord, what are we looking at?
14.
After that, my lord, the CBI investigation takes
Page
place.
14.
And after the CBI investigation.
So, J.D. Gupta,
Yeah.
the fact of the matter is,
Yes.
as per your own internal investigation, first you found about the figure will be close to 10,000.
And
But
কথা বলছো
as per your own internal investigation, first you found the figure will be close to 10,000.
10,000.
That's what you said in the affidavit.
No, not 10,000.
That's.
I don't know where my learned friend is getting 10,000.
Your affidavit because
we can calculate and show 10,000.
No. Your lordships will see lordship's own order. Not more than 10% people are tainted, your lordships. Lordship's own order dated 7/5/24.
Okay, we understood. Just one. As per, did you file any affidavit giving the sub figure of 10,000?
No.
You never filed any figure.
No, my lord. We have given a figure now of rank jumping plus OMR. I think it's coming to that 5,000 figure which Mr. Head was talking about. I'm just taking it out.
This is the chart prepared not by us on the basis of the SSC's affidavit.
That's wrong. That is not our document. My learned friend filed in Supreme Court.
It's your document filed in Supreme Court.
Lordships, the problem is SSC's.
Nobody will speak out.
Very well, because they changed
Nobody will
hands
say.
several times.
Yes, that's true.
5 minutes for rejoinder. Page number in the volume is given. 5 minutes by the clock. I missed no money.
Please wait for your turn. Nobody will speak out of it. When we call upon you, you'll speak.
Right.
Just give it.
Why is it that I'm not finding that? The calculation.
5485.
5485. But as per Mr.
References.
There it is 10,750.
That's given by me.
That's given by
Quoting from the affidavit of the SSC filed with the division bench.
Well, this is just creating confusion.
This is
Nothing
too
else.
far.
No confusion. SSC itself is confused.
No. SSC is not confused. At least for the time being, it is not.
One page. And we put in at the bottom.
Please give it with
the
the
references.
No, these figures are there in the judgment itself.
Yes. And the reference from the CPI we've given at the bottom in the foot. 10,000 methods.
Yes, that will be given from different affidavits by SSC.
Well, in this court, we have made an application which is an IA, in which not only is the figure given below, but all the names are also given.
This application, Lord, with respect.
How did you compute this figure?
We've given it at the bottom.
Yes.
Balaji is looking at 10,000.
PDF, right at the bottom, the PDF page number, volume 6, pages.
It is submission of SCC before the Supreme, before. OMR issue means that the marks in the OMR are different from the marks available with the SSC.
Who then?
Rank jumping is where somebody has been upgraded despite the marks.
And CBI gave figures which included those who are not empaneled. There is a little difference there because CBI includes those who are not empaneled, but there may be a mismatch.
Okay, fine.
But we are concerned with only those who came into the panel and there is a mismatch.
Okay, fine.
I have given a chart.
These figures can be reconciled between us also.
There's no way, the total illegal appointments are 10,750, which is 41.59% total appointment. And given the reference of SSC affidavit before the High Court.
Page number, page number.
Everything. That is not from SSC's affidavit. My learned friend has been saying these things from the beginning without reference to the record.
Page number is given.
I've given the references to your affidavit also.
Fine. Anybody now one by one.
May I take 5 minutes?
Please start from that corner. Because if you came in the last, you get the last one.
Let me just.
Your Lordships, one sentence I wanted to say. I've just handed over some suggestions, Your Lordships, to augment Tej Prakash. Because after Tej Prakash, Your Lordships, this is a very widespread problem. I'm just handing it over to Your Lordships.
I'm sorry. This is not your.
Sorry, let me just take my hands back.
I have some points on rejoinder.
Okay.
At whatever time, either in the beginning or
you finish first, and then 5 minutes we'll go by the clock.
All right, 5 minutes.
We'll stop you, anybody at 5 minutes.
5 minutes. Number one, Milord, the finding of the High Court that SSC has not cooperated is incorrect. We have filed, Milord, 4 affidavits.
Leave that part.
All right. We have filed 4 affidavits, Milord. The only effort was to segregate. Only. Well, I'll give that in a note. Number 2, Milord, the question of, Milord, there being an affidavit saying that we are not sure whether this is the last figure. These are, Milord, affidavits which are prior to the matter going before the division bench and prior to the point where the CBI has given a complete analysis of what they have found. So, Milord, that position does not hold anymore. With the CBI record, the position is complete now. Number 3, my learned friends had twice referred to, Milord, Tanvi Sarwal's case. That was an extreme case, Milord, of people having, SIM cards sewn into their vests. That has been, Milord, distinguished by your Lordships in the last judgment of Vanchika. By name, it has been distinguished, saying that this is not the approach to be followed in Vanchika. So my learned friends, Milord, have continued to refer to Tanvi without, Milord, saying that this has subsequently been referred to and distinguished. Then, Milord, the next point is that it is alleged that there are appointments, that the figures between the board and the committee. Milord, we are the commission. Mr. Hegde's client is the board. He appoints, he issues the appointment letters. We issue the recommendation, we hold the examination. Now, Milord, there is some discrepancy between his numbers and my numbers. That was what was said. So, therefore, the inference which was sought to be drawn by the High Court was that there were more appointments than recommendations. Actually, Milord, we have gone back through that record completely. It is totally reconcilable because the two parties have acted on a slightly different basis. Now, Milord, your Lordship knows that when a recommendation is issued and an appointment letter is issued on that basis, the next step is that the person must report and join. If the person doesn't report and join in that post, then there will be another recommendation and another appointment letter.
In the first instance, the board took all the appointment letters, including those which did not fructify in actual appointment, joining. Whereas we only took, my lord, those which ultimately fructified, my lord, in occupying, my lord, the position. Now, my lord, if we go through that record and we have done this exercise, if we keep aside those who did not take their appointment, then, my lord, it is completely reconciled.
That's all. Your time is over, Mr.
So, Lord, I am for those.
But may I just say one more thing, my lord? A lot is made, my lord, out of one or two things, but, my lord, the overlap between it is not followed.
Yes, Mr.
Lord, I appear for candidates who are mismatched candidates. Now, I have a basic submission to make, that is, everything is hinged on Pankaj's hard disk. Now, up to January of 2024, no other data saw the light of day. CBI realizes that only Pankaj hard disk is there, and then there is data with the board. We say the board's data is authentic. CBI must have realized they need some corroboration. For the first time in the charge sheet, which is filed in January 2024, the CBI comes out with a plea. I won't use the word story, but with a plea that there is data recovered from the hard disk of Scantech. Now, if we see the affidavit filed by CBI before the High Court, which is at page 238, they say their investigation has revealed that NASA got the job to do this. What did NASA get? NASA was to compile the data. NASA gave it to Scantech. Scantech comes to the office of the board, does the scanning there, hands it over to NASA and goes away. The question of Scantech having original record in its office cannot and does not arise. And in the charge sheet, that record is supposed to have come from a pen drive. The charge
should have been on the other side.
No, my lord, no. I am very much here. Now that record is supposed to have come from a pen drive. Today in the affidavit file, it is on a hard drive. Now all this is seriously suspect. The whole date, there is no authenticity. And therefore, my lord, we have been saying from day one, number one, that this action could not be taken until the trial is over. An investigation report submitted, there are two direct judgments of your lordship saying that
5 minutes only.
And
1.5 pages.
Second, there is no 65B certificate. I will give a 3-page written submission.
No.
I was sitting at the back. I was just no.
I have 30 seconds left. I will give a 3-page written submission fructifying this, my lord. And the data is highly, in fact, my lord, the board's record is genuine. This Pankaj Mittal's data is highly suspect. CBI is now desperately trying to get it.
Not Mittal. Mittal is our brother.
Pankaj Bansal. So, sorry. No. So, my lord, Pankaj Bansal, I will give a 3-page note. And
it only shows our love for lordships.
So, my lord, I again reiterate, and we have been saying this from day one, unless and until the data is in a trial takes place, it is highly not proper.
Okay, that's okay.
I'm for untainted, just 1 minute if your lordships will permit. That's what I'm here.
We are
one minute plus for untainted 1 minute.
I'm also untainted.
Plus just 1 minute if your lordships.
1 minute. Anybody else arguing for tainted?
Untainted, my lords.
Long time.
Untainted, innocent,
Okay,
and my lord.
5 minutes more. 5 minutes for the tainted one. Beyond what has argued earlier.
My lord, I am appearing for Group D, which is manual labor. Let's make a distinction, my lord, between the categories of people before you. We all have different grievances. So whenever they're finished, give me 5 minutes.
Sir, please argue now. You're for tainted.
Yes. My lord, my basic proposition is, when any action is being taken, justice demands that fault must be attributed where it is due. What is the fault attributed to me? I am a manual worker. I have applied under the rules of 2016. I have complied with the rules. Unless and until, my lord, I am told by way of a show cause notice issued to me that here is where you have committed a fault. The rules of natural justice have to be complied with as far as I am concerned. So, my lord, my suggestion suggestion is each and every one of us. And by the way, I don't fall in outside panel and I don't fall among waitlisted candidates. I have gone by due process of law. And therefore, I am protected by Article 311 of the Constitution of India. My Lord, I have been in employment since 2019. And my Lord, there is case law to indicate which I'll file in a written submission. Even if you don't invoke 311, you still have to comply with the rules of natural justice. So therefore, give me a show cause notice and I will prove to you that I have committed no wrong. Secondly, the admission of the state cannot be binding on me. Lord, the High Court has proceeded on the assumption that the state admits its own wrong. How is that admission binding on me? Where was I given an opportunity to oppose that admission? Then, Lord, thirdly, submissions have already been made on 65B. The simple submission is 65B has to be given by Data Scantech, the source who scanned it. They have not given a 65B certificate. Had they given it, matter might have been different. And last but not the least, my Lord, so therefore, my Lord, the crux of the matter is do not do injustice to manual labor. But that in our case, my Lord, there's no question of my trying to misrepresent myself. I've followed the rules. The rules which my learned friend Vibha read out don't apply to me. And my Lord, one last thing. My Lord, one last thing. High Court says on a balance of probabilities, reading section 3 with section 58 of the Evidence Act, they overlook section 59, which says no balance of probabilities for electronic evidence. Read section 59. It says for electronic evidence, you must comply with 65B. That's all I have to say.
I'm also
I want to.
Untainted candidates.
Untainted.
Untainted candidates. Untainted.
My Lord, may I?
I want to make a brief submission that for the first time in the entire judicial process, in this matter, after the earlier judgment of the Supreme Court, a dispassionate hearing is being given. What started off in regard to a group D by a politically inclined judge who ordered a roving inquiry, has now resulted in what has happened. Without a
Core of the matter, we have facts now.
My lords are conscious of it, and therefore my lords are now looking at it in a serious manner.
Okay, please argue something which we.
I want to say this, even the division bench unfortunately seems to have been carried away by the media hype without giving a due opportunity to all the affected parties.
Okay.
On the tainted part, may I?
Okay, 1 minute. We start from here and come down there.
3 minutes might have been several irregularities, but in regard to teachers, hardly 8 to 10%.
We know that article.
Lord, I appear for fortunately untainted people, my Lord. I am not in OMR manipulation or rank jumping. I was part of the 8th phase counselling, my Lord. Your Lordships are interpreting the rigor of Rule 15, my Lord, where the panel expires after 1 year. If your Lordships were to take that into account, from leaving the first 2 phases, all phases are impacted. Now, if I am not tainted,
first 2 phases is how many were appointed? My Lord. In first 2 phases, how many were appointed?
Phase counselling itself is after expiry of the.
After second phase of counseling.
After second phase, all are after expiry of pen.
Not
all after second phase, all are
all are beyond 1 year.
Phase counselling is after expiry of pen.
My Lord, apart from that, my Lord, another 2 types of illegalities are there, my Lord.
Lord, can I have my 2 minutes?
Yes.
Exams are going on.
Lord, I have given those dates. So
where do we get the dates of the counseling?
I have it here, Lord. If your Lordship would see at the top of the second page, Lord, the final publication was on 12th March 2018. The panel expired on 12th March 2019. Now, if your Lordship would see the second page, the 3rd, 4th, 5th, 6th, 7th, and 8th, all beyond 12th March 2019, my Lord. So, if your Lordships are going to set this aside, everything will have to go, including 9th, 10th, 11th, 12th. Now, 8th happened, my Lord, because the High Court, if your Lordship would see the second paragraph, directed that 8th phase counselling should take place. I have referred to that order, my Lord. So, my Lord, your Lordship would have to then interpret This, keeping in mind that if they are not tainted, what is it? The rigor of 15 has to be.
Okay, yes.
I can only add two things to this. One thing, everything goes, which my learned friend has said. But so far as the ninth phase is concerned, there was a direction of the High Court to hold the ninth phase counselling.
He's already argued that.
This is legal and proper and there's no challenge to ninth phase. So if ninth phase there is no challenge, it's accepted, then everything before ninth phase has to be accepted. Now the only ground that is taken by the board is that phase number 3 to 7, because there was an intervening stay of the High Court going on, so period of 8 months had lapsed. So we are covering this 3rd to 8, but they never 7. But they never went to the High Court to get an extension of time. So my lords, if it goes, then it goes from 3 to 12. But if they stay, then at least 8, because it comes before the order of the High Court for the ninth phase, has to stay.
I'm representing Group C and D.
I can file my written submissions. There's a small 2-pager note with the judgment of the High Court. I will pass it on to the learned court master.
I'm representing the Group C and D untainted candidates. The last counselling got over on 31st December 2018. Our appointments are much prior to that. We have been working since then for more than 6 years. We have not been named in any of the reports. The computer test was not even there for Group D. There is no case as against the appointees that they have done something to influence the selection or anything. In circumstances such as this Honorable Court has always held the candidates who are innocent, who has not influenced the selection, can never be punished, my lord.
And ISA got that for non-teachers. One more thing. There was no post.
Yes,
NISA was
but tender process.
Non-teachers, nobody was appointed beyond the 1 year period.
Yes, we are all within the panel, not these people, and impugned order.
Next.
May I make my submission on the?
An objection after inspection. Yes.
My lords, I'm on for the allegedly tainted group, my lords. Only 2 submissions on this. Repeatedly, the Honorable Court had put to the CBI to come forward with the metadata, which has not been done till date. Therefore, my lords ought to draw an adverse inference with respect thereto, at least at this juncture. If they were to produce it before the trial court, that then is for another day. But at this juncture, even on a preponderance of probability, my lords, there is no evidence before this court to even target a group as a tainted group. Secondly, the aspect with respect to hash value that my lords raised is very critical, because this is a classic, did the chicken or did the egg come first? Because there is no clarity in the 3 charge sheets filed by the CBI on which is the first scan. Where did Pankaj Bansal's copy, because they admit it's a copy, it cannot be an original. Where did it come from? And where and how did a data scan copy come up at a belated date? Without the provenance of a copy not being established, it is not just 4 conditions, my lords, but 6 conditions that 65B mandates. And 2 of those are in terms of the data having been created by a computer and identification of the device which created or stored it. Thereafter, the 4 conditions under 65B2 comes, which is with respect to how the computer output is made.
I'm for Group D employees.
Yes. Lord, 3 respectful submissions. One, Lord, there is no answer to the delay. But this is very crucial because...
You have understood that.
Yes. Lord, by statutory provision, OMR sheets were destroyed. That's little important. Now, Lord, the High Court records, Lord, at page 244, para 306, CBI stated that when it took possession of server of SSC, it did not find any OMR sheets in the database. Now, my lord, if SSC had no database whatsoever, how did, my lord, SSC compare the CBI, my lord, data with its own data to reach this conclusion? 1, 2, my lord. CBI also admits that they got 3 disks from Pankaj Bansal, but the data of OMR has come from Data Centec, which was not covered by 65B, my lord, certificate. Now, if you have relied upon something which is not supported by 65B, is it evidentiary? Last but most important is this, my lord. And this is little unpleasant, but kindly permit me. My lord, the entire controversy started, as I said in my beginning, because of these rank jumpers. The petition was only in respect of them that after expiry of panel, you have appointed people. They were a small group of people. They have to go out, no difficulty. during the hearing of that, Lord Justice Gangopadhyay ordered CBI inquiry without any basis, without any prayer. Lord, your lordships have seen on record Justice Gangopadhyay's interview in which he speaks.
Now we have the data, we can't ignore.
No, not data. It is important that Lord learned judge, Lord gives an interview while hearing the matter, then joins politics. Lord, the entire inquiry is tainted.
That's all.
May I make a submission, Ashok?
I don't think your lordship
I'm appearing for
not hear this because it is unpalatable to the judiciary.
Why should I say? No, we've heard you, Mr. Dave. We've heard you on that. We are not going by that. What we are going by the evidence. No, Mr. Dave, that's unacceptable remark. I'm sorry. Complete. No, Mr. Dave. No, Mr. Dave. I'm sorry. No, Mr. Dave. We will not accept that.
Great disservice to the.
No, Mr. Dave. The proceedings have gone on with absolutely dispassionately. We're going into the evidence. We are not going into any political issue. We have not allowed anybody to raise that.
How India entered is an important.
That's fine. But law in India, Mr. Dave, with your experience, you also know the law in India, settled by Puranmal's case, is even evidence collected illegally is admissible in evidence.
Not on that.
That's all. That's all.
Saying that.
That's all, Mr. Dave. No, Mr. We have understood the argument.
Next. Your Lordship, I apply for Group D employees. The Group D employees, Your Lordships, we've got Commission's recommendation as well as the board's appointment order, and we are working. Now, the allegation against us is so-called expiry of panel. There's one argument which I'd just like to place for Your Lordships. 2F of the West Bengal Service Rules says panel means a duly published panel. Now, what has happened in this case? On 28th of March 2019, the High Court had directed, that's at page 297 of volume 3. The High Court had directed that a fresh publication of the panel should be made in compliance of rules. This order was passed on 20th of March 2019. Pursuant to this order, the panel was actually published with all the required details on 20th of June 2019. And that Your Lordships will find at page 3092 of volume 2.
We have understood that.
And therefore, my only submission, Your Lordship, is number one, this is only on expiry of panel. This issue has been flagged by the High Court but not decided. This has nothing to do with the OMR issue. So if Your Lordships, again we request that what does not pertain to the OMR issue and panel issue, either Your Lordships or some committee appointed by Your Lordships or the High Court should decide. They're actually, and the issue is pending.
My lords, I appear for my lords.
We'll come back later.
Yes, my lords.
My lords, I am for the OMR. My lords, may I?
Okay, please.
My
You've
lords,
already taken your time.
I'll be brief, my lords. I will stick to my time. I am for those with the OMR mismatch, my lords. My lords, when we do not demolish entire cities because some buildings are bad. What do we know today, my lords? We know today that there are rank jumpers. There are people who have been appointed outside of the panel. The SSC has said that and the West Bengal government has said that. And they, my lords, of course, cannot be part of the teaching contingent. But my lords, with regard to the OMR, the only evidence there is, and my lords, I have these notes here. The only evidence there is that of one accused.
We have understood this.
And my lords, the data scan text. My lords, at page 5, when I've opened the page, my lords, my lords, may I just complete this point? Just this point, that Pankaj Bansal's own data is not matching with itself. It's at page 5, my lords. My lords, if I may just very quickly complete. It's a new point that has not been noted so far. My lords, it's at page 5. It is that the data sets recovered from Pankaj Bansal's possessions are OMR, DAT files, marks in a DBF file. It is important to remember that the DBF file recovered from him do not match the OMR sheets recovered from him according to the CBI charge sheet itself. Number one. Number two, the OMR sheets also do not match the marks in the file named so-and-so sent to Pankaj Bansal by one Atul Srivastava.
CBI
That's may I.
Is it correct that some OMR sheets were also recovered from Pankaj Bansal?
Yes, ma'am.
No, Pankaj Bansal will recover OMR sheets, data?
No, they don't.
The scanned version, ma'am. Scanned version of OMR sheets, my lords, and DBA files and DAT files.
Lords, may I just point
and they do not match each other. So how can we rely on Pankaj Bansal?
My lords, one para which will clarify your lordship's doubt, which
You
will
said that
just
the data was matching. Now the learned council says that the data was not matching.
No, data is matching from
What is it that didn't match then?
No, so I'll just clarify it. First of all, the data from the data scan take, the hash values, if I will correct myself, the hash values do not change if the data is copied from one computer to another. So the hash value that we got from the data scan take matches with the hash value that was there in the Pankaj ones. So the hash values match. The modification time, that means when the data was originally created, is also belonging to the 2017 period.
Find on data scan text computer.
Data scan text also is supported by 65.
What did you find there?
Data scan text
Data scan
again
is
the
not
scan
supported by
copy.
65.
Scan copies of the OMR?
Yes,
It's not supported by
those were
65
deleted.
my lord.
Those were deleted, but we recovered it.
You recovered that?
Yes.
Subtended, right, by nice.
All of them.
All of them.
The commission of.
Okay.
That's all. Your time is over.
Para 305, my lords, para 305.
Wait for it.
Three short submissions. Your lordships will today check insofar as my IFF of Group C and D untainted. If there is not even a single allegation against them, my lords, today on a doctrine of proportionality, I need to be protected. But just one more.
My lords, may I now? My lords, may I now?
They had in the reply stated that there are documents, my lords, which show that even if not one of the OMRs were marks have been given. That in fact goes to show that the OMR are from Pankaj Bansal are accurate. They have not been interfered. What has been interfered with is the marks which have been taken.
Yes,
Therefore, please treat that as sanitized and clean and act on that basis. That's why.
May I? Not sure. I've been waiting with it. May I take 5 minutes, sir?
Complete
Please, your lordship will give me 5 minutes. I'll take 4 minutes first. This is a note. The first part, allow me, sir, please. The first part is 5 errors in the High Court. My main written submissions are page 92. Please refer to them, that your lordship, your lordship has seen them. The other 5 errors I have put. I don't want to read them, but segregation is the core. I am C and D untainted. Segregation is the core of the issue. Well, we say segregation is possible because A, the allegations do not reveal any systemic flaw. Every irregularity, rank jumping, OMR mark mismatch, appointments after expiry of panel are after the fact of proper conduct of OMR, after the fact. Second, it is no one's case that the completed OMRs or its scans were manipulated. CBI's case is that manipulation is at the stage of data entry of the marks onto the server of the SSC, namely after the scanning and evaluation. This is very, very important, Malas. I've given the reference to CBI affidavit. The CBI has also filed an additional note on the last date vouching for the authenticity of the scanned copies recovered from Pankaj Bansal in data scanning. The CBI's investigation is complete, comprehensive. It was done under a Lordship's order of November 2023. They filed a charge sheet, 3 supplementary charge sheet. Other than those identified as beneficiaries, there is no challenge to the CBI's findings from untainted candidates or any of the state authorities. This is very important, Minister. CBI not only identified the accused, also all beneficiaries. It is CBI's position in their written submission that they are able and willing to provide details of individual candidates who received appointments. Then why not segregate? Why a blanket approach? Just 1 second, sir, let me finish. I've still got 1 minute left for this. Why should you not segregate? Because a blanket, one size fit all, has grave injustice. 1 minute more and I'm done with this. Next page. They have raised no valid ground against segregation. SSC has failed to file an affidavit saying the number of valid appointments. Blank OMR sheets have been submitted by candidates, yet they've been appointed. SSC and state authorities destroyed the OMR sheets without creating a mirror image. I've given a page. I'm not going to save your shift time. I'm not going to any of the pages. Massive corruption on their part, costs of 500 crore, etc. Suggestion and re-examination be conducted only for those candidates who have previously participated. Because I am saying that the arguments against segregation are either non-arguments or illusory, and there is no valid argument given. Segregation does justice. A one size fits all is very, very dangerous.
When I did my opening argument, Lord, there is not a whisper on the other side with regard to any irregularity in the examination. Because your lordships have dealt with a large number of cases where the exam itself was not cheating, copying, SIM card going, etc. has happened. Here there is nothing of the sort. Even today they have not said that there is, neither has the CBI said that anything was wrong with the examination. There is nothing wrong with the result also. What has happened is not that there is a original found outside
and what has been found in the SSC is different from what is in the original. That is how the premise is there. That this is original, this is the original mark sheet which was taken on the basis of the exam, and what is in the SSC website is different from the what is the original in the Bansal. And those are the tainted, that's how the numbers have been identified by the CBI. Now, Lord, a very important question has arisen, and that is what is I feel also troubling your lordships a little, that at the time of hearing before the High Court, the state authorities took a stand that there could be more, and that is something which is a little disturbing. I was also feeling how to answer that. Problem lies is very simple, Lord. For the state to admit that this much has happened is an admission that something wrong has happened. They could not, at least in the preliminary stages of the hearing. Now, of course, they have now taken a very clear, candid stand. But at the preliminary stages of hearing, to say that yes, this much has happened is an admission that yes, I have done something wrong. They could not have said that I've done something wrong. So they just wipe their hand off by saying that we don't know, we don't know. That we don't know doesn't mean, not that, one second. We don't know doesn't mean that, we don't know doesn't mean, just last word, Lord. We don't know doesn't mean that there could be other methods of wrongdoing.
But 2 seconds, I took 3 seconds earlier. Okay. 2 paragraphs, in total 5 seconds. 2 paragraphs, my lords, which will clear lordships all doubts about the authenticity of the data and the hash value. Please note those paragraphs, that's all. Para 305, 289, one more thing, just one more thing, my lords, just one more thing. In the concluding paragraphs, when you direct custodial interrogation of those tainted, how is it possible that you say that it cannot be segregated? We left our government jobs. The only prayer, as my learned colleague requested me to put it to my lords, was that do not cancel the selection was not the prayer. The second thing is we left government jobs to come to my lords. And the last thing, without taking more time, my lords, is that permit me written submissions to point out those paragraphs.
My lords,
Yes.
2 points, my lords.
Come on.
My lords, just 2 points. I represent untainted Group A and Group B teachers who've been teaching for the last 6 years. In our groups, the CBI has found only 8.5 and 14.4% to be tainted or irregular. What is the way forward for people like us who are a majority of these candidates who have been teaching in the state? The way forward is in Inderjeet Singh KHANNA, your lordships in 2006 said only if a majority of the candidates are tainted should you set aside the whole process. That is not the case here. Secondly, in Vanshika last year, your lordships sitting in 3 judges said very clearly that you must segregate because your response must be proportionate. If your response is to set aside the entire process, it is disproportionate and it is injustice to a majority of Group A and Group B teachers who have been teaching in the state.
Great, Millard. Couple of figures, Millard, I would like to point out, Millard. The total number of vacancies for class 9 and 10 was 12,905. The total number of vacancy as advertised in 11 and 12 were 5,712. The total applicant for 9 and 10 was 1,41,000 and odd, Millard, and for 11 and 12, Millard, was 1,50,000, Millard. There were first 2 writ petitions, Millard, that were filed. One is Setabuddin, Millard, and the other one is, Millard, Soma Sinha. Millard, Soma Sinha was discontinued, Millard. Ours were the 3rd writ petition, Millard. We were the original whistleblowers, and Lordship will kindly take, Millard, one order passed in our matter, Millard, that would appear, Millard, at page 602 to 604 of our compilation, Millard.
Yes.
Here, Millard, a detailed order was passed, Millard, wherein, Millard, Lordship will kindly take... I'm sorry, Millard.
602 of which volume?
602 of, Millard, this is volume 4, Millard. I'm sorry, Millard.
Yes.
Millard, here, Millard, a detailed, Lordship will kindly take, Millard, internal page 2, Millard, where, I'm sorry, Millard, it's volume 3, Millard. I'm sorry, I'm a bit confused with so many volumes, Millard. I have just made quick notes, Millard. I'm extremely sorry, Millard. Dr. Patro, Senior Counsel for the Commission, also files a report in the form of an affidavit wherein the manipulation of the marks in the OMR sheets of the above named candidates has been alleged. Let it also be kept on record. I'm reading from internal page 2 of that order, Millard, at page 603.
Please read it again.
Yes, my lord. Lordship will kindly take, my lord.
What is the date of this order?
This order is of 2nd of February 2023, my lord. This was the order, my lord. I may not, my lord. I will only point out the paragraph once, my lord. That is, my lord, Dr. Pathrod, Learned Counsel for the Commission, also files a report in the form of an affidavit wherein the manipulation of marks in the OMR sheet of the above named candidates has been alleged. Let it be kept on record. Thereafter, my lord, Dr. Pathrod submits that the recommendation of the above named candidates were erroneous, my lord. So there is an express admission with regard to that. Coming thereafter, my lord, on the basis of this order, my lord, there was a subsequent order that was passed, my lord, on 8th of February 2023, my lord.
Yes.
Page 605. These are here, my lord, on the 2nd of February's order was quoted on the very first paragraph, Lordship will find, my lord. This quote, by the order dated 2nd of February, directed the Commission to file an affidavit disclosing the modalities to be adopted by the Commission in exercise of the powers under Rule 17, my lord. Pausing here for a moment, my lord, what does Rule 17 speaks of, my lord? Rule 17, time and again, all my learned colleagues, my lord, have cited, my lord. Rule 17 empowers the Commission, my lord, to, my lord, withhold or withdraw or rescind any recommendation that has been made, my lord. The power is vested exclusively with the Commission. Now, my submission with this regard is the moment the Commission exercises the power under 17, it sets the clock back to where it was originally. That is, my lord, at the time of 12.6, which my learned friend Miss Makija was referring to, my lord, with regard to publication of panel and etc. The moment, my lord, some of the people have been taken out where there is an express admission with regard to erroneous inclusion in the list and 17 is applied, my lord, we actually do a time travel, my lord. We actually go back and start the process afresh under 12.6, my lord. One more, my lord, one more line, my lord. I have 40 seconds, my lord. I will conclude, my lord. For the period of 9 years, my lord, people who have applied and were not called for verification, my lord, they would be inured to the benefit of their service period, my lord. They have lost everything, my lord. They tried, my lord, all ends up, my lord. They tried to get into the...
I have prepared a note. I have just prepared 1-page note. I just want to say one line. Because we are those who are working from 1999 and we were confined to one zone. Thereafter, we got an opportunity to go and to do it centralized posting. So we got centralized posting. We were selected. We are not in the tainted list and we got our pay scale the same as what was there before. Pay protection, provident fund protection, service protection. So everything was protected.
1 minute.
So therefore, my lord, I am only
division bench.
So there, my case is sui generis, my lord, in that sense, that it has nothing to do with the
division bench.
Much obliged.
This court, while remanding, told the High Court to assess, the admissibility of the scanned OMR. That's a principal question. The matter was referred to CFSL, Kolkata. That's a part of the order which I read. Kolkata, my lord, after Hyderabad refused, went to Kolkata. Kolkata is still not examined. The High Court has still given a finding about the admissibility, number one. Number two, the only other way, to find out of whether it is tampered, one is CFSL, the other is hash value. So if you have the original hash value, every time there is some tampering, the hash value changes, right? But here, unfortunately, original hash value was not taken. If you don't get starting line, you can't go to the next line. Therefore, the High Court committed a gross error in ultimately saying that we accept the certificate of Pankaj Bansal, notwithstanding 65B may not followed, but we rely on Section 3 and Section 58 of the Evidence Act to accept his OMR, notwithstanding, that Pankaj Bansal was nobody to keep the hard disk. There is one more hard disk called Niladri Das, which has surfaced. There is one CD, which is missing, untraceable. In the face of this is stated in the charge. In the face of this, how do you, segregate one from the other? As far as I am concerned, this is not enough to knock out three
Your
points.
Lordship may permit me.
No, there's one point of the state.
Your Lordship may permit me. Your Lordship may permit me for untainted candidates, my Lord. This is one page note. Your Lordship may have it. No, this my note is here, my Lord.
Yes. Half a minute,
My Lord, my note is here. Just 1 minute. My note is here, my Lord. If your Lordship may have it, my Lord.
Yes.
My submission is, my Lord, your Lordship may accept the investigation that have been taken place till now as it is. We are untainted. We left the earlier employment and joined here, and through all the scrutiny, we are still untainted. My Lord, your Lordship, just see page 1. There are 3 categories. I'll just quickly in 1 minute sum up this, my Lord. There are 3 categories according to me, my Lord. This is one is OMR mismatch. Second is rank jump and out of panel. And third is excess appointment. As far as first 2 categories are concerned, your Lordship may see the box. In the first category, I have given all the paginations where this list is there. Your Lordship may turn the page. For the second category, the list is there. As far as the third category is concerned, which is excess appointment from the panel, this comes out of para 271 of the judgment. Now CBI or somebody has coined this this excess appointment 1539. The list is not there. What is the basis? That is also not there. Now, your Lordship may just read this with me, my Lord, this about this 1539 and 199. This is the source of this figure in para 271 of the impugned judgment of the Honorable Court. From the record, we do not find that the CBI has given the data or they have found excess appointment of teaching categories. CBI states that they will provide the details of individual candidates who received appointment illegally as mentioned in different tables set out in written submission, see para 12 of volume 6. All the appointees have recommendations subject to clarification by CBI. There is possibility that these sets of person may fall in earlier categories like OMR number mismatch, rank jump, out of panel. Hence, this number could be hypothetical. This is my submission, my Lord. Last one is, my Lord, that there is a portal of a state government. On that portal, all the details of all the appointed candidates are there. And there is no single appointment which is without recommendation of the commission. That's how I have been instructed.
Okay.
Last thing, my Lord. Because we have left our appointments, my Lord, earlier employment, my Lord. We are in the middle of our ages, my Lord. We have children, my Lord. Your Lordship may apply the principle of segregation and protect those who are untainted and innocent.
Yes, please.
Lordship, most important point I have to bring on the record. Lordship, the main petitioner, BAISHAKHI BHATTACHARYYA, she is at now 54. She is not bona fide candidate. She is now at 54 age. At the time of examination, she was 40.
Just 30 seconds.
And other mark, my points are given in there.
Okay, fine.
No, I am giving 2 judgments here where my lords have held, because this court has laid down that in the case where there are 2 categories, illegal appointed and properly appointed, then if there is a possibility of segregation.
Taxi away, please.
Well, there is.
Need not argue on that.
Well, I have only one sentence. Well, I have
one sentence. Integrity of the process, we come back to as the basic question, my lords. 3 judges bench in Anwar's case.
Well, I have one sentence, my lord. There is one side is the dishonest candidates, other side the honest candidates, and there is SSC and the state. As one line short, so that the innocent, honest candidates, they do not lose.
Okay, fine.
They are trust in the system.
Just 30 seconds to lock up lines. I am in the category of the untainted, and we say that we should be segregated, which I therefore adopt the arguments of Dr. Singhvi and others. Just one thing, I am just handing over a note. There are at least, according to our calculations, 20,000 people who appeared, who have given up their jobs, etc., and coming. And for instance, clerical staff, assistant teacher.
Just now only the state council.
Yes, I just want to say one thing, I am appearing from day
30 seconds only.
I mean, I beg petitioners from way one, may I just point out?
Look, we will not be able to.
Just 30 seconds only.
May I just point out the things, submissions which have been made by the CBI are totally contrary to the records. Today, for the first time, the CBI has handed over and said, following the inspection, no candidate disputed the authenticity OMR images shown to them, asserting that they are not theirs. Now, specifically, there is a affidavit to that effect. Kindly comes to page 656. Yeah, just 10 seconds.
Just 10 seconds.
Lord will give me just one line. Just one line.
Just 10 seconds.
Their admissions are just one line.
Just 10 seconds.
If I just kindly point out the affidavit,
Please sit down. We have audio.
May I show only one paragraph, Malad? Only one paragraph. How did we reach to the authenticity? 308, only one paragraph.
Please, we have gone through. We have heard you.
Just one line.
Just
10 seconds.
That's all.
Just 10 seconds, Manoj. I beg to appear for the waitlisted candidates. There is an issue as far as appointment of these waitlisted candidates to supernumerary posts is concerned, which is pending in the High Court, my lord. And that writ petition, my lord, is 25056. And ultimately, my lord, just one more thing, my lord.
Lord, may I point out a logical infirmity in the judge's in the impugned order. Lord, paragraph 240. Lord, the judge, the division bench segregates and says these are unduly high percentages. Lord, segregation is by perforce possible. Lord, I would urge your lordship to make.
Lordship, permit me one sentence.
No,
Lordship, please permit one sentence. I promise I will not repeat what has been stated. There are 3 hard disks. The first one, there is no hash value, and the entire data which Pankaj Bansal and Scantech, which has been come out and they're talking about being genuine, is from that hard disk, which there is no hash value. Even in the 65B, para number 285. The first one does not have a hash value, and the entire data, it like comes out of a PC Sarkar magic show. The entire thing comes out and says, yes, Pankaj Bansal data is correct, so is Scantech. That the entire thing comes out from one hard disk, which does not have a hash value. That's it.
May I just add one line? May I just add one line?
Can I base that's over?
One submission.
We have to bring it to
one submission, Milord.
We have
On
to
behalf
bring
of
this to closure.
one submission, Milord. Kindly consider.
No more, please. That's all.
Kindly have page 161.
High Court records that
Yes, please.
there is a clear data. One.
That's all, please.
One line can add.
Sir, maybe just unmuted for a minute. He wants to make one submission on our behalf in item 4.
I am appearing for 18 blind teachers, my lord, and they were already in service. They took these exams for promotion. They're in the untainted lot. There are 18 blind teachers. One of them has been given benefit by the High Court at paras 360 to 362. We're asking for parity of treatment with that person with disability. These are 18 blind teachers who are already in service.
Why did you not ask the High Court itself for the same relief?
Malaj, we were not made parties. We were not aware. We were not aware. We were not parties, my lords. That's how we did not realize that our appointments are going to get cancelled.
And Lordship, the retention period of 1 year, I just wanted to show pages 355 and 376 of volume 5. It is the standard practice for the retention period only to be of 1 year. So nothing that SSC was doing was uncommon. Secondly, if we may be given a chance to show subject-wise segregation.
No, that's not possible. That's not possible. No, that's all, please. Yes, Mr. Devendra. Mr. Muridhar, just give us the detailed names of those 18 candidates.
I'll do that. I'll do that.
We are aware of that argument, Mr. Bala, we are aware of that argument.
Yeah, just one submission before the government council. The submission is essentially this, that your lordships, having heard the state council now and the state agencies, it's quite possible to go ahead with segregation.
Yes.
Now, if that is the case, my lord, on a principle, proportionality was canvassed. Just consider the situation of persons in service for 7 years, 10,000 teachers untainted whom I represent. So I would urge your lordships, balancing. So I think it's possibly a duty for constitutional court that where segregation is possible, to apply that rule, unless it's completely impossible. It appears here to be possible. Agreed.
While adopting Mr. Diwan's argument, my lord.
Please, no more, that's it, no more.
On the last decision, the Lord just put one question to the state to answer. Lord, that was regarding the observation in the High Court judgment that there is widespread, state has accepted that there is widespread. Lord. I only say this, Lord, that there have been irregularities, Lord, there is no difficulty on that, Lord. We accept that position, but widespread only means, Lord, that 50% and 6 virtually faults were found, Lord, with regard to Group C and Group D, Lord, by Justice Bag's committee by that time, Lord, and 10%, Lord, as the Lordship saw the percentages. So therefore, what we mean by accepting widespread, Lord, is that only and nothing more than that. It doesn't mean, Lord, that there is something more.
Arguments are judgment reserved.
No, Lord, there is one. The point that's remaining.
Let me accept our written notes now.
There's this one small. Lord, I have something else.
Lord, I'm for the board.
The point which your Lordships reserved for me, Lord, is regarding entirely different. That is regarding CBI investigation, which your Lordship said I'll hear later on.
That point we did take it.
Our written notes are
submitted. That is with regard to the supernumerary force.
The order which we passed, which expressly mentions at page 368 that it is subject to the orders passed by the High Court. Number one. Number two, Lord, there is in the petitions which have been decided, none of the petitions challenged the government order. Number three, Lord, there is another petition pending, which is writ petition 25056 of 22, where, Lord, specifically this order was challenged and it was stayed. So no appointment has been made, Lord, pursuant to that government order. The next aspect is, Lord, that the reason for issuing the order was that since, Lord, certain infirmities had been found, therefore, Lord, we said that subject to the orders passed by the High Court, from the wait list, it doesn't say illegal. The order says at page 368 that from the wait list, Lord, will be appointing, Lord, because there are so many large number of teachers who are going out, Lord. If all of them go out, Lord, the whole education system will fall there. So therefore, Lord, we left it to the High Court that if, Lord, something which is found, we can account.
That's my point also, my lord. We have exams. We have exams which end. We have exams which end in April. Results come in May, my lord. Your lordships may take it back.
The submissions